Court officer. Court officer. Court officer.
ಆಗಲ್ಲ ಸರ್, ಇವು ಭಾರಿ
ಹೇಳಿ ಮೇಡಮ್.
ಹಾ, ಯಾವ್ದು ಲಿಸ್ಟ್ ತಗೊಂತೀರಾ ಫಸ್ಟ್? ಯಾವ್ದು ಲಿಸ್ಟ್ ತಗೊಂತೀರಾ ಫಸ್ಟ್?
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್.
ಫಸ್ಟ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಥ್ಯಾಂಕ್ ಯು.
listing, my lord, from last many memo has been filed.
Yes,
Some-
take that.
Same matter, my lords, what transpires is from 2023, my lords, I filed several memos not listed. Lords, the auction.
Oh, you're seeing the list. All, we have
Any
already completed 22.
Let's-
23 will come. No memo for that. Yes, call the list.
Some urgency is there, my lords.
Submission. My lords, serial number 19, your lordship,
Huh?
list one, serial number 19.
Wait,
Withdrawing.
wait, it will be
22,
called.
my lords, can I pass the memo, my lords? 2022, my lords, some
It
urgency.
will come. The matters are coming. I will not take any memos.
My lords,
Yes,
one installment is departed, my lords. They are taken position, my lords. Only for one installment. Subsequently, I have paid that also.
so what?
My lords, they have taken position, my lords.
So what is the writ petition? When is it filed? Which year is that?
Yeah,
Nothing you
It
state.
was filed the day before yesterday, my
It
lord.
will come if the office objections are complied with. If it's
It's
not,
complied, my lord.
tell the court officer. Yes, call the list.
Official look, branch way submitment. Page number 10, list number 1, adjournments if any. Sheet number 44 to 52.
Which is this? तो ऊपर नहीं, थोड़ा नीचे और नीचे. That's the last one. Yes. थोड़ा ऊपर. Yes.
Page number 11, 53 to 59. Page 12, 60 to 63. List number 2. Page number 2, sheet number 5 to 9. Page number 3, 10 to 12.
Yes.
Serial number 12, madam. Appeal for petitioner.
Hmm, list
Serial
number
number
two.
2, list petitioner.
No, list number 2.
List number 2, serial number 12, madam.
Oh,
Appeal for petitioner in this case. Seeking for adjournment, madam. Some
Why?
inconvenience.
2022 matter. I'll not adjourn, not even one matter. Yes.
Lordships kindly for dismissal, interim order not complied for dismissal. And next week, any date? Posting.
No posting, ma'am. Yes.
For dismissal, serial number 1, Abhinav R.
No, somebody was mentioning about some serial 17 or.
19, your lordship.
Oh,
I'm withdrawing the petition, your lordship. It has been
Take
settled.
that.
19. 19, first. Dismissal.
The memo is filed stating that the matter has been settled out of the court, as the petitioner wants to withdraw the petition. And accordingly, memo is taken on record and dismissed as withdrawn. Yes.
Thank you.
Serial number 1,
My lord, I am appearing for the petitioner.
Yes.
My apologies, my lord, yesterday, it's not
Yes.
keeping well, I could not.
Yes, yes, yes.
My lord, in this matter, my lord, the respondent number 4 was directed to, my lord, place on record the steps taken by them, my lord, for,
Let's see what is the prayer.
Please,
Who are the
ma'am.
respondents?
my lord, they have challenged, my lord, the constitutional, my lord, validity of, my lord, section 25B of the RDDB Act.
On what ground?
My lord, here is a
that.
case, my lord, where
Use the act.
reconstruction, act is ready.
RDB Act. Yes.
25B.
Section?
25, my lord, subclause B. My lord, prescribes, my lord, modes of recovery of debts.
Hmm.
My lord, clause B, my lord, says arrest of the defendant and his detention in prison. My lord, in our case, my lord, I was an ex-director of the company.
No, not about your facts.
Please.
Why that is ultra virus or ultra constitution?
My lord, straight away, my lord, they cannot proceed without, my lord, exhausting the other remedies available under the act. My lord, here, my lord, in the present case, straight away, my lord, the respondent number 3, my lord, has issued an arrest warrant.
We will not go into the facts of the case. You
Please.
have, when you're questioning the constitutional validity of a
Yes.
particular project, you have to argue on that. Why is it bad?
My lord, please take, my lord, section 19.
I'm looking at it.
Yes, section 19, subclause 7.
Yes. Yes. Are you prepared?
I'll get prepared in the matter.
Afternoon,
I request, my lord, for day after tomorrow, my lord.
Tuesday is a bench, day after tomorrow. That's on Monday.
Yes.
Yes.
Lords, just one submission. I appear on behalf of the official liquidator. Insofar as the prayer against the official liquidator is concerned, my lord, it's already been satisfied. We have funds.
We'll decide it on Tuesday.
Obliged, ma'am.
List on Tuesday. Yes, two, under the same caption.
Petition, my lords. I apologize, I could not appear yesterday, my lords.
Yes.
My lords, in this case, my grievance is against the first respondent, my lords, that is the bank, my lords. The property is an ancestral property of the petitioner and second to fifth respondents, my lords.
A demand notice is issued on 5/6/2017.
Yes, my lord. My lords, in this case,
Demand.
my lords, the petitioner has got nothing to do with it, my lord. The property is ancestral property, my lords. The second, third respondents have colluded against each other, and the third respondent has got the property.
Are you not supposed to give a reply to them? Under 13(2) saying that the proceedings cannot be initiated against me?
No notice was issued to me, my lord. It was issued only to the borrower.
You have questioned the notice.
Yes, ma'am. Later I could obtain the notice from the bank itself, my lords, but I was not served any notice as such, my lords. The notice was served on the fifth and sixth respondent, who are the borrowers. Now, deliberately, they have avoided paying the money to the bank so that they can take over the property, my lords, through backdoor method, because it's an ancestral property.
My lord, I filed my IA to vacate, my lord. In fact, it is the housing loan which is obtained from by R4 and R5 for house construction. It's a site which has been funded in construction of house. So, my lord, they have filed a partition suit after the property has been mortgaged. And my lord, if that is the case, the only contention of the petitioner is that there is a pending suit. Lord, if that is the case, writ petition cannot be kept pending for years together, my lord. They are not proceeding with the suit. There is a stay. Demand notice, they can approach the DRT or they can file any remedies in the civil court itself. Why should a writ petition be kept pending, my lord?
So at 13(2), where will they go?
No, my lord, 13(2), they can approach DRT, my lord, or at the time of taking possession.
My
lord, we seek to rely on this. They cannot seek stalling of demand notice. My lord, may kindly see that the housing loan in my objections. Lord, here also it is a partition suit.
What is this judgment? Which paragraph?
My lord, yes. Lord, in this case, clearly they have said that the partition suit, my lord, HUF property, on facts, any person includes plaintiff, my lord, in this head note, who has filed civil suit challenging sale of secured property on the ground the same of HUF, thus irrespective of maintainability of civil suit, remedy lay in section 17. So if there is a partition suit and they're seeking a stay, they have to approach DRT. Lord, here is a case where the site was purchased by R4 and R5 and constructed based on the funds given by the bank.
Sale deed is in the name of R4 and R5.
Yes, my lord. Sale deed is in the name of R4 and R5.
When was that site purchased?
2014, my lord. 2014. And my lord,
what is the relationship between 3, 4 and 1?
Cousins, my lord. In fact, the sale deed has been executed by R3 in favor of R4 and R5. R3 is the uncle.
No.
Yes,
R3, R4 and R5 are also related.
Yes, my lord. R3 is the uncle of the petitioner. So, my lord, the petitioner is the son of R2. R2 and R3 have executed sale deed in favor of R4 and R5. Based on that, they have approached the bank for house construction and we funded the house construction. The house is being constructed and house construction is complete. Thereafter, R4 and R5 have defaulted in the loan. In 2016, the account was declared as NPA.
What is the amount? What is the
around 36 lakhs. So now there is no recovery coming from R4
what
and
is
R5.
The amount?
36 lakhs, my lord. Sanction, my lord, sanction amount is around 40 lakhs, my lord. And now current dues are around 36. I produced the sanction, my lord, at R1, my lord. 19 lakhs is the limit sanction, my lord.
When was the suit filed?
Suit was filed in 2016, when it became stressful account.
And purchased in 2014.
14, my lord. Mortgaged in 2014. April 2014.
Purchase is also in 2014.
My lord?
Purchase is also in the year 2014.
Yes, my lord. Yes, my lord.
Yes.
My lords, may I take your lords to the decision? Respondent number 2 and 3 are the brothers, my lords. Now, respondent 2 is the petitioner's father and respondent 2 is petitioner's the uncle. Now, respondent 2 and 3 colluded with each other because respondent 2 is a mild and he is not a very learned person, my lords. Respondent 3, taking advantage of this, he instigated his brother to join in executing a sale deed in favor of his daughter, that is respondent's 3 daughters.
Let us take all your contentions to be true or to be correct. what is the relief you expect from this court?
My lords, my only apprehension is that before I could prove my share in the civil court, my lords, by that time, if the first respondent takes over the property and auctions the property, then I lose my right, my lord, because I have got 50% share in the right.
No,
Now,
your suit will take 5 years, your appeal will take 5 years, further appeal will take 5 years, till such time bank shall not do anything.
no, my lords, my only apprehension is let 50% of the property be untouched, my lords, and another 50%, which anyhow it is going to be coming to this respondent 3 to 6, my lords. Let the bank do anything with that, my lords. I have no impediment. But my share, let it be.
That kind of a relief we cannot grant in a writ petition.
My lord, in such circumstances, my lord, if the bank auctions the property, where will I go, my lord, being a genuine inheritant of the property?
You have gone to the civil court, you can go to the DRT, and this can't go on like this. The writ petition is filed, seeking the following.
May I make a request, my lords, in that case? I may be permitted, may I make a request, my lords, in that case? If the court is not inclined to extend the stay, my lord, I may be given liberty to approach DRT with condonation of delay, my lords.
Yes, no, not condonation or delay. Whatever is,
Further measure can be.
whatever, I mean, this is pending from 17 to now.
The notice has become
From that
inflicted.
day, he is entitled for the whatever under section 14, whatever is the benefit.
Lord,
No, Lord,
2017 is
now the
quite
notice
9
has
years,
become
my lord.
inflicted. Because of lapse
It's
of
almost
time.
9 years of delay, my
There is
lord.
an interim order in this.
Yes, my lord, he has been, yes, there's an interim.
Then
order.
how can you say that he is not entitled for the benefit?
My lord, in fact,
Please come. Agreed with the order. The present writ petition is filed, seeking the following prayer. It is the case of the petitioner that the second respondent is the father of the petitioner and sixth respondent. The third respondent is the brother of the second respondent. Fifth respondent is the daughter of the third respondent, and the fourth respondent is the son-in-law of the third respondent. The sixth respondent is the first son of the second respondent and brother of the petitioner. The second respondent, along with the third respondent, had jointly inherited the property bearing house number 2447, new number K36, measuring east to west 18 feet and north to south 16 feet, were registered partition deed dated 29/4/2014 and were jointly in enjoyment of the same. The third respondent, taking advantage of the mind nature of the second respondent, got a sale deed jointly executed in favor of his daughter and son-in-law, that is respondent number 4 to 5, while registered sale deed dated 22/4/2014. The respondent 4 and 5 in turn mortgaged the property in favor of the respondent bank, and by way for a registered mortgage deed dated 29/4/2014 and availed the loan for construction of the house. The petitioner accidentally came to know about the same during January 2016, and also about the notice that is issued under section 13(2) of the Surface Act. As such, he has come before this court questioning the said 13(2) notice. When counsel appearing for the petitioner submits that he has already instituted a suit in the year 2000.
16, my lord.
Huh?
2016, OS 126 of 2000, OS 125 of 2016.
OS 125 of 2016 on the file of the
Lord, second additional senior civil judge, CJM at Mysore.
second edition senior civil judge and CJM Mysore, and the same is pending consultation. It is submitted that during the pendency of the suit, if the property is auctioned, it would cause lot of hardship to the petitioner, which made him to come before this court. It is submitted that this is a case of fraud played by the respondents, unless the further proceedings initiated by the respondent under the Securitization Act or interdicted by this court, it would cause lot of prejudice to the petitioner. Next part. When counsel appearing for the respondent bank submits that the respondents 4 and 5 or 3 and 4?
4 and 5.
Respondents 4 and 5. A registered sale deed is executed by respondent number 3 and 6, sir.
No, my lord, respondent
2 and
number
3.
4 and 5.
2 and 3.
Yes.
Respondent 2 and 3 have executed a registered sale deed in favor of respondents number 4 and 5 in the year 2014. And immediately, and after that, they approached the bank, and the bank, by mortgaging the said property, has granted the housing loan. It is submitted that right from the year 2016 to 2026, the said suit is pending. The suit is filed after the mortgage to the bank, and the said suit is pending consideration. It is submitted that till the rights of the parties are crystallized, the bank cannot be stopped from the continuing with the proceedings under the Surface Act. It is submitted that the petitioner has an effective remedy basing on the further steps to be initiated by the bank to approach the DRT, and he cannot come before this court. It is submitted that a stay was granted in the year
2018, my lord.
2018, and from that day, from the last 8 years, the bank is not in a position to proceed with the matter. And the suit is still pending.
Yes, my lord, the suit is still in the evidence
He
objection
relied on the
stage.
judgment of the apex court in case of Jagdish Singh versus Hiralal and others. Which paragraph?
My lord,
Paragraph number 24.
Yes.
Relying on that, it is submitted that the remedy available to the petitioner is to go before DRT, but not before this court. Next, having heard the counsels on either side, there is a material on record. The petitioner has questioned the notice that is issued under section 13(2) on the ground that the property is a joint family property, and a suit is pending, voice number so and so. That's already read. Right, no? So suit number, voice number so and so is pending on the file of so and so. Or coordinate bench of this court on which date is the interim order?
9/1/2018, my lord.
9?
9/1/2018.
On 9/1/2018. Interim order was passed, observing that in the meanwhile, taking note of the contention put forth, respondent number 1 shall not lift up the physical portion in respect of the portion in which the petitioner is in occupation until further orders are made herein. According to the petitioner, the property is a joint family property. In that regard, he has filed a suit. The suit is filed in the year 2016, and from the last 10 years, the suit is pending before the court. The proceedings under the Surface Act are stayed by this court. That is pursuant to the notice under 13(2). From that day till now, the bank, being the secured creditor, could not proceed with the Surface proceedings. The assertion or the case of the petitioner or the claim of the petitioner that it is a joint family property and the bank is initiating the proceeding, that itself cannot be a ground for the court to stall the proceedings. Admittedly, there is a sale deed in favor of the respondents number 4 and 5, and they have taken the loan. They have taken the loan from the bank in these circumstances, and also this court has perused the judgment relied on by the counsel for the petitioner in Jagdish Singh. Jagdish Singh's case referred supra. In the light of the above, this court is not inclined to entertain this writ petition. Accordingly, this court is passing the following order: the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT, basing on the subsequent the proceedings that are going to be initiated by the bank under the Surface Act. The time that is spent, the petitioner has a benefit, shall have the benefit of section 14 of the Limitation Act.
Number 3, 3K.
I seek apologies.
For the
not
respondent
appear.
9, my lord.
My lord, the petitioner died in the petition, my lord. LR application is filed after the period of
Oh,
limitation.
where is this DRT proceedings if the proceedings afresh by issuing notice and all, isn't it?
No,
I am for the respondent 9, my lord. If you are
Huh?
on the performer part, respondent 9.
He is also guarantor.
Who
Petitioner
appears for
also-
the bank?
Lord, the proceeding is still pending because he is the guarantor. My lord, I am-
No,
Yes.
who is the bank? Which is the bank?
Indian Overseas Bank.
Till now it is not served or nobody is appearing. Respondent number 2
Venkatesh Shastri.
for R1 and R2. Where is he?
Venkatesh Shastri.
Indian Overseas Bank, who else appears?
Indian Overseas Bank. Who is representing?
Who are the panel counsels? You have the list, I think. List is there. You there? Hmm? Hmm? It is there with, Anita was there, ask. Yes, Mr. Vignesh Shetty. Who else appears for Indian Overseas Bank? You appear?
I don't appear, but I'll inform the council.
No, the borrower is no more. The borrower is no more. Now you have to initiate the proceed. Now, if at all you are entitled to recover the money from the LRs, you have to initiate fresh proceedings. All the proceedings will go, isn't it?
According to me.
That's a law.
No. They have
Irrespective
to issue
of.
fresh 13-2, bringing LRs on record.
Uh,
They have to issue fresh 13-2, 13-4, issuing notice to the legal heads on record.
So everything will start afresh.
That's what.
Yeah, my lord, but actually I think it, because there are
No.
four properties
No,
are.
what is the prayer in the writ petition? Come to the prayer.
My lord, page number 35, my lord, typed copy is at.
Quashing the impugned order dated passed by debt recovery tribunal.
Yes,
Oh, this is an order by the tribunal.
yes, my lord. Page number 38, my lord. So it is dismissed, sir. Still
What is
notice-
the order passed by the debt recovery tribunal?
38, my lord, typed copy is at 38, 38. It is LCR of, K-Beta present, submits that the sale notice for challenge did not take place for want of bidders. Hence, D number, sir, 2026.
Where is page number?
38, my lord. I'm typed copy I'm reading, but order is at page number 35, my lord.
38. Let's see.
It's in bracket. 38 is the typed copy. Order is at 35, my lord. In fact, no, sale proceedings not taken place, hence this,
You have questioned this order.
yes, my lord.
What is there in this order?
And also, my lord, it is next page, my lord, page number 43, my lord. So it is ordered to pay rupees 15 lakh on one bit and 10 lakhs one bit towards the court fee. I also subsequently it is passed, my lord. In fact, we are the guarantors. And my lord, the first respondent recovered the insurance amount of the deceased person, Lokesh, who is the
No,
borrower.
let's not, please don't confuse the court.
And all, yeah,
Come to the prayer. Prayer one, number 1. How can, what is wrong with that order?
here I have a question, because the court fee is raised, my lord.
26/11/2020 order, Mr. Counsel.
Yes, my lord, it is.
What
page
is
number
wrong in
35.
that? No, what is the order that you read now? Just now at 38.
Yes, that is typed copy, my lord.
LC where appellant and K-Waiter present. K-Waiter submits that the sale notice challenge did not say take place, want of bidders, hence dismissed as infructuous.
And in the meantime, my lord, the left side, my
Let's
lord.
go to that later. No, let's go to the other order later. First you tell about this order.
Yes, in the same page, my lord, 38. IN number 1, 2113 of for early hearing. Next, IN number 2114 of 20 for to pay the court fee. IN number.
Please
20
come to page 30.
Yes, my lord.
First
I'm
you tell
seeking
the
setting
court,
aside the order date
first you
26.
tell the court about order dated 26/11/2020. So there is nothing wrong with the order dated 26/11/2020, isn't it?
Next.
Yes. So now please come to the next order.
Prayer 2.
23/12/2020. Where is the 23/12/2020 order?
It is at page number, my lord. '51, my lord. It starts from 49, typed copy. Relevant pages at page number 50, my lord. It has challenged impugned order I action notice dated so and so issued by the first respondent bank pursuant to which scheduled property is scheduled on 50. I am reading, my lord, typed copy. And next, my lord, 2312 is in 51. Shashidhar advocate filed for respondent bank, A waiter filed LCR both present. IA1 complied, respondent bank wakalat e-sale which was challenged did not. Appellant filed IA for determination of compensation. IA filed for 14C. Application may file as challenged from have become infectious and to be dismissed. Hence, IA so and so dismissed as infectious.
You have a stay in this matter.
No, my lord.
Then what remains in this now?
My lord, now I want to bring the LRs of the petitioner.
Not bringing the LRs.
Yes.
This is
IA is filed already.
writ petition of the year 2021. The
Yes.
order is confirmation of the scheduled property will be automatically vacated and first respondent bank will be at liberty to proceed further in accordance with law is the order.
Yes.
What is the present stage?
My lord, the bank has to say for all these things.
Why the bank is not interested to contest the matter, 2021 matter? Nobody appears.
And moreover,
Please
we are
come.
the guarantors, my lord.
It is submitted. Tell the advocate that now I will grant the stay. Tell the advocate that now I will grant stay. No, writ petition of 21 is listed, that they don't even feel the necessity to come and appear before the court and tell the court what is happening. This is a matter of 2021. And when the matter is listed under the caption dismissal, the counsel appearing for the bank has not even appeared before the court. It appears that the bank is not interested to pursue this matter. Considering the merits of the matter, this court is inclined to go pass interim order in this writ petition. List this matter tomorrow.
2 days party
Let
has
it
come
come,
from.
let me understand what it is, what is happening or what has happened after that.
No, I'll make my necessary. 2 days, my party has come today from Monday, my lord.
List this matter on Tuesday,
Yes.
no further time. Under the same caption.
But 4, yes, and now we are.
For the petition, I'm sorry, my lords, could not appear yesterday, my lords.
Yes,
But
yes.
not received the copy of the statement of objections as noted in the office itself.
Please come to the
Please.
order. Please come
Annexure,
to-
yes, my lord, is the sale proclamation.
What have you, where is your prayer?
But the prayer, my lord, is at page number, my lord, it was 19, my lords, page number 19. Writ of, in the nature of certiorari, any other.
Proclamation of sale dated
Yes,
25
annexure, yes, my lords.
in recovery certificate bearing number.
Yes, yes, my lord. Lord, the dispute is only with respect to non-deduction of subsidy amount paid by the central government. Lord, this fact is admitted by the bank,
Was
29
it
lakhs.
agitated before the tribunal?
Please, no.
Was this fact agitated before the
Lord,
tribunal?
Lord, it was subsequently sanctioned. After disposal of the OA, Lord, the central government has released the funds. Lord, which fact is admitted? Kindly see annexure C, Lords, for a moment, Lords. Annexure C, the bank
Yesterday,
admits.
somebody was submitting that in respect of these kind of calculations and all, the recovery, they can make an application to the recovery officer.
Lord,
And the recovery officer can consider that.
in the earlier writ petition, what we have filed, Lords, this honorable court was pleased to direct us to approach the bank. We approached the bank. Bank did not respond. Then, my lord, legal notice was issued. In the legal notice, my lords, they have conceded. And, my lords, kindly see, interim order passed by this honorable court in the present writ petition, my lords, on 20th/4/2021. The other side has conceded that they have received some amount.
What is your,
Still,
who appear for the bank?
I'm for the R2, Your Honor. The amount has been deducted. After the deduction, it is outstanding is 39,48,092 rupees, Your Lordship. And I have no information because my senior was earlier attending. This file is missing also, so I may request some.
These are all 21 writ petitions,
I request
stays or
some-
there. If
I
the bank is
request-
not showing any interest, I don't know.
1 week,
what to
1
say.
week.
You know,
time,
this matter
Your
has come up
Lordship.
yesterday, it's going to come today. And
Yes,
you,
Your Lordship.
whoever your senior or you should have had the instructions by this time.
He has been elevated. He is not in Bangalore or Karnataka. So I request some time. Since it is a matter of 2005, Your Lordship, OA was 299 of 2005.
No, bank is there. Bank is there or bank is already.
I'm not getting the bank's phone number also. I'm just.
Which bank is that?
Indian Bank.
You appear for
Bangalore
Indian Bank?
branch.
Who appears for Indian Bank?
My senior was.
That's what anyhow, you're not getting instructions. We'll ask somebody who is on the panel to get instructions.
One more colleague is in the panel, so I'll get the information. I just need a short accommodation, Your Lordship.
Interim order earlier granted is extended until further orders. List this matter after 4 weeks.
Number 5, L. Srinivas Babu.
I appeal for respondent, my lord. Matter is settled, they made the payment and it may be closed.
Huh?
The matter is settled by one.
You appear for the bank.
I appear for bank.
Land council appearing for the respondent, bank submits that. The entire amount is cleared and the loan account is closed. Taking the submission of the land council on record for the respondent bank. The petition dismissed as instructions. No representation on behalf of the petitioner. Yes, 6.
6, Chidambara.
Yes.
My lord, I have challenged the order passed by the DRT at annexure A on limitation point, my lord. My lord, the respondent number 2 has mortgaged his property.
Shruti Sauharda Sahakara Bank Niyamita. What is this?
It's a cooperative bank, my lord.
Sauharda Bank.
Sauharda Bank.
Hmm.
My lord, the respondent number 2 has availed a loan. He mortgaged his property, and my property is a different property. My lord, the property belongs to me. Is identification measurement is totally different. My property measuring 600 square feet. What they are claiming that the mortgage is 1,200 square feet of property, my lord. They have initiated proceedings under Surface Act with regard to 1,200 square feet property. And ultimately, my lord, they have taken physical possession of my property that is measuring to 600 square feet. Now, my lord, they have proceeded under Surface Act and they have sold the property under Sauharda Act. I have challenged the possession notice before DRT. There is a delay of 55 days, Your Honor. And my lord, the delay, DRT has dismissed my appeal based on the delay, Your Honor.
Not only delay, locus standi is also.
My lord,
When it is his property, why he doesn't have a locus?
No, it's not his property. That's what our contention.
Where are the documents to show?
my lord, my lord, kindly come to page number 27, annexure B. I have purchased the property from respondent number 2. Kindly come to annexure B, Your Honor, my lord, page number 27.
Dated?
Sale deed dated 11/6/2001.
You purchased from?
From respondent number 2.
Respondent number 2 is a borrower.
Yes.
He is the borrower.
Then, when was the mortgage?
Mortgage was in 2001, my
Date?
data. It was on 1/6/2004, my
2004.
2004.
4. That is much before, much after his sale.
Yes.
Mhm.
My lord, prior to that, Your Honor, the respondent number 1 has purchased that property from No, my sale deed,
Civil dispute, my lord, he has to go to the civil court and establish his rights. And moreover, my lord, he has an alternative remedy. He has to approach the DART against the order of DRT.
my lord, the latest.
Since he has, we have
No,
disputed.
in a matter of this kind, a person purchases a property in the year 2001, your mortgage in 2004, and the extent of the property that is
2009
mortgaged-
he has purchased, not.
No, he says
No,
2000.
my lord, sorry, my lord.
2009.
2009 one, my lord. But my,
2001.
no, my vendor, the respondent number 2 has purchased the property in the year 2001. Same dimension, same measurement. Same property has sold to me. It is also measuring 6,600
What
square.
is the property which is mortgaged to
My
you?
lord, annexure R2, this the sale deed, my lord.
I have produced their mortgage deed, my lord.
Page number?
At annexure V, page number 95.
16, my lord.
95.
95. The memorandum of deposit of title deed.
95.
5, page number 95, annexure V, my lord. Kindly come to my lord, the description of the property at page number 99. I read the description, man. Movable property bearing number, old number 146, presently bearing number.
1 minute. This according to as per this mortgage deed, his sale deed is dated
16/5/2003, my lord.
16/5.
2003.
Absolute sale deed number.
Yes.
Dated is not there.
Yes,
That
My
is
lord.
16/5.
annexure R2, ink page 16.
16/5/2003. So the second respondent has purchased the property by way of a sale deed dated 16/5/2003.
Kindly see the schedule. Schedule.
No, the
Yeah.
extent of the property which he has purchased
Yes,
is,
madam. He has mortgaged that property.
let's see
Please.
that, what is the
Please.
extent?
Yes.
Khata number situated it with an area measuring east to west, north so and so, bounded by so and so. What is the extent? Where do you get it?
See, ink page 22, my lord.
I'm looking at your mortgage deed. Please refer to that only.
Measuring, my lord, there. The area measuring east to west.
Kindly take my objections, please, my lord.
I have produced a
Objections.
certified copy of the
It is
mortgage deed.
His document. I have produced the document. Kindly see annexure R2 of my statement of objection. Ink page 16.
Your statement of objections are not on record. Is it there?
Sir,
Where is the statement of objection? This is the one. That's not the statement. It is not there. You have a copy?
yes, my lord. 16/7 I have filed.
He has not served a copy of the objection to me also. Without serving, he has not served a
I
copy.
have sent him.
Not received.
R2 or either there are two advocates. That's the confusion. My lord, annexure R2 in page 16 is the sale deed.
This is on 16th May.
Correct.
Purchased from whom?
From V. Nagraj. This is the borrower, Nanjundaya. Nanjundaya is the borrower.
From Nagraj, yes. What is the extent? Please
My
show.
lord, ink page number 22, my lord.
Yes.
My lord, all that piece and parcel, so and so and so, east to west measuring 60 feet. Third line. North to south 20 feet. My lord, he borrowed the loan, my lord, in the year 2003, my lord. He was sanctioned loan on 1/6/2004. First loan. My lord, this mortgage was encumbered in the encumbrance. Kindly see ink page number. I have marked that.
My lord, the what he's,
1 minute, 1 minute. We'll hear you also.
My lord, it is there, my lord, at ink page number 13, my lord. I have marked that, my lord, Sushruti, last document. Mortgage, yes, my lord. After mortgage, my lord, he did not repay the amount, my lord. So the bank approached the,
So,
yes, my lord.
pausing there.
Yes.
Now please come to the sale deed of the petitioner.
Yes.
Page number. Where is your sale date?
B, 27. Ink page 27. This schedule is east to west 30 feet, north to south 20 feet. Same property. We
Come
do
to
not-
that.
Yes.
This is, no, there must be a mention how he has purchased this property.
Nothing is forthcoming there.
No, this is 2001.
Yes.
What you are referring at 27 years.
20.
But he has purchased in 2006.
Next is Annexure C, my lord. That present petitioner has purchased in the year 2000.
Page number.
Page number 35. Annexure C. 35. Yes. Ekana is the petitioner.
When he has purchased?
He has purchased on
3rd
September
September 2009.
Yes.
Now let us see in this, the vendor or the absolute owners of the piece and parts of the movable property.
My lord, in page 37,
Bangalore.
last para, my lord.
1 minute, Bangalore. Measuring so and so.
Nothing is
20, measuring east to west 30. Which is 3rd floor building, deed of sale registered as document number 11/6/2001. Yes, that is the source of title to this property is something else.
for my,
My lord, what happened, my lord, this document we are not aware because he is not a party. It's only between the borrower and the bank. Borrower is respondent number 2.
No, his case has to be considered then.
Correct, my lord. But the property which we have mortgaged, we have put into action. He is disputing that property. So he has to adduce the evidence. He has to approach the civil court.
For that, the court has to entertain his petition. Otherwise, how will he?
No, my lord. What happens, my lord? Actually, my lord, the property which was mortgaged to us, my lord, that has been sold. He himself has handed over the possession. He is aware of the proceedings. He willfully has not colluded with the second respondent. From the day one, my lord, is not allowing the second respondent to represent before the court. In this case also, my lord, he has not done. In the proceedings before the register, my lord, an award has been passed after considering all the objections raised
You
by.
can only look at the document that are placed before the court.
Please.
He is his source of title to the property.
Yes, my lord.
And the document on which the vendor of the petitioner has source of title are two different things from your property which is mortgaged to you. No, whatever is his contention, unless and until that is decided by the court, you cannot proceed.
No, we already sold. We have already. He has given the possession. He has given an undertaking.
After purchasing the property, I have purchased the property.
My lord,
what undertaking he has given?
My lord, he has given a letter. Kindly see, I have produced that. He has approached the civil court. He got dismissed. That civil court under a rule.
I approached the civil court, no doubt.
What happened to your suit?
Suit dismissed, saying that you approach DRT. DRT is the competent authority. You approach DRT.
He has challenged the notice. He has not challenged the award till today, my lord.
I have challenged it. I enclosed the copy also. I have challenged.
Kindly see, my lord, annexure R6. The suit.
My lord, kindly come to the memorandum mortgage deed created.
And he has approached this honorable court twice. Got dismissed. He never allows the respondent number 2 appear before the
I
court.
can only pass orders and understand the way how I can understand. So you have, both of you have to argue how I understand the matter.
Please.
So please answer to my queries,
Yes,
nothing
please.
else.
Yes, ma'am.
Yes, what happened to you? When was the suit filed?
Shall I answer, my lord?
Yes.
My lord, it was filed on 19/5/2016. Annexure R6.
When was the award?
My lord, it was Decree was done on 18th December 2019.
Have you questioned this 18/12/2019 award?
No,
I have not filed any appeal against the order of the.
Then what purpose would be served by entertaining this petition?
But meantime, what happened? They have taken physical possession of my property. My lord, I have challenged the possession notice before DRT. So I have not preferred any appeal against the judgment.
You have to, it is an independent proceeding.
My lord, if I succeed in possession notice,
Basing
my
on
lord,
this award, they sold the property, they're doing so many things.
My lord, he
And you're
himself has
being,
given an.
please
sorry,
wait,
sorry.
you're being a mute spectator to all this.
no, my lord, they can't sell my property. My
My
lord, kindly.
They have sold.
Let me complete.
They have sold.
My lord, what happened? They have proceeded under.
Whatever happens, without impleading all the proper and necessary parties,
Yes,
you
ma'am.
can't contest the matter.
Yes,
My lord,
Having aware of the fact that it is, property is sold, possession is given.
my lord, kindly.
he himself has ended
For
up,
one-
kindly see
kindly come to
annexure R4 and
Mortgage
R5.
deed for a moment, Your Honor. They have proceeded.
See annexure R4 and R5. my lord.
Proceeded against me, against the property which is measuring 1,200 square feet. My lord, ultimately they have sold the 600 square feet in under Sauharda Act. How it is possible? Man? Why they have not sold the 1,200 square feet property? They have proceeded, they have obtained section 14 order, they have proceeded a 13-2 notice, their 13-4 issued for 1,200
Is
square
this
feet.
contention correct?
They have sold, my lord.
Kindly see annexure R4 in
They have
page
sold.
30. my lord.
Before I see that, you please tell,
Please.
what is the extent of land mortgaged to the you?
20 by 60. That, yes, my lord.
Let him show mortgage deed, my lord. Let him show mortgage deed. For 1,200 square feet.
Hello. It is-
600 square feet. Let him show.
my lord, all this question has to be decided by the civil court, my
We
lord.
will decide, we will understand.
Please.
First, at least for the understanding of the court, you can tell the facts.
Yes, yes, yes. So in mortgage, right now.
I have produced mortgage deed at annexure V. Kindly see for a moment, Your Honor. The measurement is 1,200 square feet. And the description of the list of the title deed, my lord, which is not pertaining to the mortgage property. I have taken certified copy of that sale deed also. Kindly come to list of title deeds which.
While entering, my lord, they have correct some mistakes, my lord, by something, my lord. That's not the thing. My lord, after mortgage, my lord, the mortgage, the borrowing was earlier than his purchase, my lord.
My lord,
Date of borrowing is our, encumbrance has been entered, my lord.
The list of title
When there
deed.
is a charge over the property, he, without verifying the documents and without, he has purchased the property.
No, I
Can
can
you
say
see
that
the
without seeing the
encumbrance?
document, they
This
have
is
mortgaged the
happening, I'm
property.
not able to understand. For every line of you, whatever you submit, he will respond. Whatever he submits, you respond. Is it
Sorry.
possible for the court?
Sorry.
Yes.
My lord, after mortgage, my lord, that has been encumbered. And the borrower has never appeared before any court, my lord, except before the jurisdictional register. There he has sustained the award. Award is there, my lord, they have not challenged till today.
We are only on the point,
Please.
whether the DRT was right in passing this order.
Yes, my lord.
For that,
Yes.
prima facie, we
Yes.
have to look at all these documents.
First thing,
On the documents,
Yes,
on the
first
prima
thing, my
facie,
lord.
look, it appears that your bank having properties mortgaged was 1,000 square yards. And because the borrower and his vendor is one and the same, now you have sold the property of 600 square yards without identification of the property.
my lord, DRT's order, my lord, is only with regard to locus standi and delay.
That we will set aside.
Delay, my lord. Kindly appreciate this, my lord. Delay, my lord, he had a knowledge. My lord, since from 2016, he has come before different courts, my lord. He has not approached any this thing, and he has not challenged any this thing. Delay starts from 2016.
Please
when-
come to the impugned order.
Yes, ma'am, come, please. My lord, relevant,
Annexure A, my lord.
in page.
When did you file the suit?
Suit in the 2016, my lord.
16,
Then that suit was disposed of when?
19, my lord.
19.
Date?
18 December 2019. And again, he approaches this honorable court by way of writ petition. Kindly see annexure R7 in WP number 1196 of 2016. In page 47.
Let's read the order.
Yes, please. High Court order, madam.
DRT order.
DRT, yes. My lord, ink page now. From Parasis, I'll read. Admittedly, there is a delay of 55 days in filing the present case. In the affidavit filed along with the delay application, it is contained that the applicant is the absolute owner of so and so and so, and so and so is in possession of property. The respondent bank, without any security interest, has taken his possession by invoking Subsidy Act. May I read?
None of his contentions were considered with the tribunal.
Only on limitation point, the tribunal has dismissed my appeal, my lord.
Not only on that, my
There is
lord.
a delay of
This is not
just
an-
15 days, 55 days.
Cumulative examination of facts and the documents produced by the tribunal concludes that the applicant is not an aggrieved person. Why not?
Because he is not neither borrower nor this thing, my lord.
But bank is taking the property of somebody else.
No, my lord, it is not his property at all.
That the court has to decide.
No, not the DRT, it is the civil court.
No, what is the jurisdiction of the civil court?
My lord, he has to lead evidence because title is disputed, boundary is disputed, measurement is disputed, and we have.
No, you initiate the surface proceedings and you take possession of a property. Can the
No,
borrower?
surface.
Under the act, and the borrower, whoever is aggrieved, will go to the civil court and file a suit,
No, my lord.
and that suit is maintainable.
No, not like that, my lord. Earlier, a dispute was raised before the registrar. Registrar has passed an award. That has not been complied. Under that circumstance, it has Surface Act has been.
So even a civil court decree is also there. And if a person who is unconnected with whose property, which is unconnected with the decretal, listen to the court.
Please.
If the decree holder under the guise of the decree is going to take over possession of the property, the obstructor has a right.
No, my lord, there
He has
is a
nothing to
delay.
do
He has
with the
kept
suit.
quiet. He has kept quiet. Already sold. They have taken possession.
Fresh cause of action arises once possession notice issued.
Please come. Agreed with the orders passed in SA number 378 of 2020 dated 16th August 2021. The applicant is before this court. The petitioner is before this court. The petitioner has approached the DRT by filing SA number 378 of 2020, questioning the order passed by the magistrate under section 14 of the Surface Act. The petitioner is a third party to the loan transaction and also the measures initiated at the bank against the borrower and the mortgager. It is the case of the petitioner that he has purchased the property from one Nanjundaya White Sale Deed dated 3/9/2009. And the property is measuring an extent of 300 square yards.
600 square feet.
Measuring 600 square yards. The vendor of the petitioner is the borrower and he has mortgaged the property to the bank in the year 2000. When was it? 2003.
Mortgage, yes, ma'am.
And as per the
2004.
2004. And as per the mortgage deed, the extent of land is
1,200 square feet.
1,200 square feet. The 1,200 square feet. And he has purchased the property in the year 2009.
9.
How can it be 2000? Not he, the vendor.
Vendor.
The borrower.
Borrower.
The LD date they have not mentioned.
He has purchased a property in the year 2003.
Yes.
Whereas the petitioner's property is concerned, the vendor has purchased a property in the year 2001. It is a case of the petitioner that the property, as the borrower has another property and which is 600 square yards and the mortgage property is 1,200 square yards. The respondents have taken possession of the property of the petitioner who is unconnected with the loan transaction. It is also when the petitioner has filed a suit before the civil court that came to be dismissed as not maintainable, and the petitioner was
Under order 11.
under order 7 rule 11. When an application is filed, the court has rejected the plaint as that the court has no jurisdiction. Against that, the petitioner has filed a writ petition. Writ petition is also
Not that, my lord. Challenging the order of notice, he has filed the writ.
Then after that, instead of approaching the DRT, petitioner has filed a writ petition before this court. When the court has directed them to go before the DRT.
No, he himself has withdrawn.
He has withdrawn the writ petition. Writ
Dismissed
petition,
without reference.
seeking liberty to go before
No,
the
sorry,
DRT.
my lord. He has not complied the office objection, hence it was dismissed.
As he has failed to comply with the office objections, the writ petition was dismissed.
Again, another
Thereafter-
writ petition was filed in WP number 41419 of 2019, challenging the notice, my lord, under the Surface Act. And
13-2 notice.
It was withdrawn, dismissed as withdrawn.
Another writ petition was filed questioning the 13-4 notice and the same was withdrawn. Later, the petitioner has approached the DRT. The DRT, by order impugned, had dismissed the writ petition on 2 grounds. One is that he has come after 55 days from the date of the order passed under section 14.
Notice.
Under 13-4. After 55 days from the 13-4 notice. And second, the petitioner has no locus.
Is not an aggrieved person under
Is
section
no
17(1)
locus
of the.
as he is not an aggrieved party.
No,
And the
that is
order
not
that is-
observed in order.
Till 22.
Kindly
Para 22, my lord.
kindly
Is
come
that-
to page number
The
25.
cumulative examination of facts and the documents produced by the tribunal concludes that the applicant is not an aggrieved person under section 17(1) is not justified in challenging the measures under the act.
Yes.
At page number 25, for ongoing
I've read
reasons,
the order. I know what are the contents of the order. For that also, I don't require any.
only IA
arguments on
dismissed,
that.
my delay IA dismissed.
Yes,
Reasons
the
are
court, both on the ground of the delay and also on the ground that the petition is not an agreed party, has dismissed the petition. Agreed thereby, the present writ petition is filed. When counsel appearing for the petitioner submits that the petitioner is an aggrieved party, as the property belonging to the petitioner is sought to be, is being attached as per the award. It is submitted that when a property of 1,200 is mortgaged to the respondent, and the respondents have now the property of the petitioner is only 600 square yards, and that property is attached. It is submitted that the said action of the respondent bank is backed, as he is as all these have emanated pursuant to the orders passed by the DRT, and as he is pursuant to the orders passed by the DRT, the petitioner is an affected party, though he is not a borrower, and these aspects were not considered by the court. Next, when counsel appearing for the respondent submits that the petitioner has not questioned the award that is passed. They have sold the property and the position is already given
And-
without questioning all those proceedings.
And he has not taken steps for the borrower to come on.
And he has not taken any. Why should he take steps?
Because, my lord, he has made a party. He has deleted that party.
He has not taken steps to bring the borrower.
He is dispensed with the permission of this honorable court only.
That's what.
On previous
He
occasion.
has not taken any steps to bring the borrower to plead the borrower and take steps. It is submitted that now the auction had taken place
And
and
it
the
is sold.
possession is already given.
Given. He under himself has given the acknowledgement for having given the possession.
Has been-
Annexure
has
R4
been
and
No, no,
the
we-
possession.
R4 and R5, it is there. Sorry.
Has given the possession and it is submitted, has given the position, it is submitted that at this point of time, all these disputed questions of fact cannot be decided by this court, and the remedy available to the petitioner is to go before the civil court.
And DREAT.
And alternatively, he has also a remedy before the DRAT, questioning an order that is passed by the DRT. It is submitted that the order passed by the DRT is a well-considered order, and there are no grounds to interfere. Next part, having other counsels on either side, peruse the material on record. The petitioner has purchased the property from the borrower an extent of 600 square yards. The mortgaged property is 1200 square yards. It is also an admitted fact that what has been attached is a property of 600 square yards. The petitioner questioning these in this regard, with regard to this dispute, has filed a suit before the competent court, where the respondents have filed an application under Order 7, Rule 11, and the court has rejected the plaint. Now the submission of the learned counsel for the respondent that he has to go before the civil court, the submission has no legs to stand. When he has come before the DRT, the finding of the DRT that he is not an aggrieved party cannot be, that finding of the court finding of the DRT cannot be sustained. When a person's property under the guise of a mortgage deed of the borrower, if the petitioner's property is being attached, the petitioner is an affected party and the aggrieved party, and he has every right to approach the DRT. And the court has observed that he has come before the DRT after 55 days from the date of 13-4 notice. The court has already observed that he is not the borrower, and just because the public notice is given, that itself cannot be a ground for the court to come to the conclusion that he has come to the court with a delay of 55 days in questioning the 13-4 notice. The whole purpose of the timeline that is prescribed under the DRT, under the Surface Act, is to see that in an effective and a speedy manner, the disputes between the parties, between the parties is effectively adjudicated. In the facts and circumstances of this case, where the petitioner is not a borrower and where it is pleaded that his property is being attached under the guise of a mortgage deed, and the property in the mortgage deed and the property that is purchased by the petitioner is not one and the same. This is an issue that has to be decided by the tribunal. In that view of the matter, this court deems it appropriate to set aside the order. Accordingly, the writ petition is allowed. The order impugned dated so and so is set aside, and the tribunal shall hear the matter on the merits of it. If the borrower is not a party before the DRT, the petitioner shall make the borrower as a DRT before the DRT.
Timeline.
The DRT shall decide this within a period of 6 months
Much of it.
from the date of receipt of the copy of the order.
7,
May I have that objection. Objection.
I'll give it to him.
Ayat Nitya.
May I appear for the petitioner, madam. My apologies, yesterday I was not present in the case. Madam, the petitioner herein is a widow who lost her husband during COVID-19.
Come to the prayer.
Please.
Come to the prayer.
Madam, page 19, my lord.
You have questioned the demand notice.
My humble submission is, my lord.
Oh.
Prior to the death of my husband, my lord, he was regular in making the payment, my lord. The bank is HDFC
When
Bank.
was the securitization proceedings initiated?
After the death of my husband, my lord.
Notice is issued to whom?
To the wife. To the wife, my lord. And I claimed the amount under the insurance, my lord, by the, insured by the HDFC Ergo, my lord, as suggested by the HDFC Bank, my lord. The loan agreement also provides that the loan shall be secured by the insurance.
First
And
of all,
HDFC Bank shall be the beneficiary, my lord.
13-2 notice itself is not it's not a step under the Securitization Act.
Please, I will make it clear. The insurance company repudiated the claim, my lord.
When they issued
I
a notice,
approached the consumer.
please understand, when you issued a notice under 13-2, whatever your submissions are you not supposed to reply to them?
My lord, immediately I approached the.
Why should you approach this court?
No, I didn't approach initially. I approached this honorable court. I approached the District Consumer Forum, challenging the repudiation of my claim under by the HDFC Ergo Insurance, my lord. Now, the subsequent development is, my lord, District Forum has allowed my complaint, my lord, and order has been passed. That was challenged by both the insurance as well as the bank before the State Commission, my lord. And the State Commission has also confirmed the order passed by the District Forum.
Then these proceedings will go.
My lord. The HDFC Bank.
They stayed in the National Commission.
Please.
It is state.
Yes, my lordship.
My lord,
Against,
yesterday I got the.
But then in that case, you cannot proceed till now they have an order by the State Commission, by the District Commission. Now, how can you proceed?
And while passing the interim order also, this honorable court considered the order passed by the District Forum on previous occasion, my lord.
Till the SLP is concluded.
Since last three years, I am not in question.
You have lost in two courts, two tribunal, the District Commission and the National Commission. I mean, the State Commission. The matter is pending before the, unless and until it is settled. That the whole crux of the issue is what is to be decided by that. So don't proceed till that is decided.
My humble one submission.
Yes.
In this submission, already the National Commission has stayed, my lordship, and producing this.
My lord, National Commission has stayed the order insofar as the bank is concerned, my lord. Under the SURFACE provision, my lord, District Forum has no jurisdiction. That is the well settled principle, my lord. So far as the bank action is concerned, the order passed by the State Commission has been stayed by the National Commission. So far as the order against the insurance company is concerned, my lord, as per my knowledge, as on this day, no interim order has been granted, my lord.
And one thing is, this honorable court has been passed an order to make a payment of 20% of the outstanding balance, my lordship. That also not complied by them, my lordship.
Is it so?
On order was passed
initially, immediately after taking the possession, I approached this honorable court. This honorable court was pleased to grant the conditional order. Subsequently, considering the order passed by the District Forum, my lord, on 3/8/2022, this honorable court was pleased to extend the benefit of interim order, my lord. Kindly consider the order passed on 3/8/2022. This is the latest order, my lord. Well, the call this matter after 2 weeks. The interim order granted earlier shall continue. The continuation is made in the light of the order made by the third additional Bangalore Urban District Consumer District.
Interim order shall continue means that the conditional order shall continue.
My lord, the interim protection. So for the
it will continue on the same condition. The judge never said that because in the light of this order, that condition imposed earlier, that is vacated or that is modified.
My lord, otherwise the conditional order was mentioned that if the condition is not complied, interim order shall stand rescinded. That was the order previously passed, conditional order, my lord. Subsequently considering.
He just said the interim order earlier granted shall continue for the reason that this order is passed. What is the outstanding amount?
My lord, total loan availed was 36 lakhs, my lord, 37,60,000 in the year 2017.
As of
husband passed away on July, in the month of July 2020.
As of now?
As of now, 58 lakh 14,000. In 2020, they are last paid EMI. On that time, they are paid. In 2020, they are last paid EMI, my lordship. From 6 years, they are not paid any single EMI also. Present outstanding is 58 lakh, my lordship.
What is the order of the Consumer Forum?
Consumer Forum is till
directing the insurance company to settle the entire loan amount.
Insurance company is directed to settle.
Directed to settle, my lordship. They are the bank is the beneficiary, my lord. Unnecessarily, last 3 years I have been deprived of the possession.
Do you agree with the fact that the apex court has granted stay as far as the bank is concerned?
National Commission.
As far as National Commission, as far as you are concerned, there is no stay.
Yes, no, it is stay.
It is stayed.
No, he
Let
says
them
there is no
produce.
state. Store.
I have not received.
Store that.
No, no, let them show.
Get that order.
Lord, I don't have right of. Banks.
Let them show.
The main ground of appeal in this matter is that the consumer forum do not have the jurisdiction to interfere with the procedure pending under the Surface Act.
So for the OP2 is
Issue
concerned,
notice on the second appeal as well as on the continuation of delay application.
OP2 is concerned.
Operation of the district forum as against OP2 is state.
Bank, against bank.
I'm for the OP to bank, my lord.
Then you are supposed to pay the money.
Please.
No, my lord.
You have not prepared any appeal.
Lord, I have prepared. and
Where
I
is
will-
your
I will
stay?
obtain it. I will obtain it.
Submission you can be.
The National Commission advocate is going to send it to me directly, my lord. Yesterday I called them. It is stayed and they will inform me.
My lord, my humble submission, I will give the undertaking before this honorable court in the form of affidavit also, my lord, saying that let them at least give back the possession of the property unless since last 3 years, my lord, no one is making use of, my lord. I have 2 children, my lord. At least I can save 15,000 as a rental, my lord, which I am paying, my lord. I will give any undertaking before this honorable court, my lord. Let them be a bank is the beneficiary, my lord.
Interim order earlier granted is extended until further orders. This is matter in the month of June. Delete from the caption dismissal.
So far as the
Right.
possession is concerned, my lord.
Kavita,
My lord, in this case, I'm for the petitioner, my lord. Liberty may be given to approach the DRT, my lord.
Liberty may be reserved to move the matter, disposal, instead of
Liberty is reserved to move the matter. If once the matter is disposed of before the state commission, national commission. Yes, the present writ petition is filed seeking the following prayer. When the matter came up, and counsel the petitioner submits that the liberty may be granted to approach the DRT. Accordingly, the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy in accordance with law.
number
Oh,
9,
bless me.
Ramesha BM, serial number 9.
This is the writ petition of 2022. And after complying with office objections, after 2020, the matter was listed only on 4/3/2026. No interim order is granted, and there is no representation on behalf of the petitioner on 4/3/2026. And the matter is directed to be listed today under the caption for dismissal. Today also, there is no representation. Accordingly, dismissed for non-prosecution. Yes, 10.
N. Rajendra,
Yes.
Very for petition, Your Lordship. Your Lordship, we don't have any instruction from the client. Matter may be disposed of. We don't have any instruction from the client from last
Then
many
counsel
dates.
appearing for the petitioner submits that he has no instructions from the client. The present writ petition is filed seeking the to questioning the order. The present writ petition is filed seeking the following prayer. The initially interim order was granted in the year 2022 and it was extended on 23/7/2024. Thereafter, on 9/1/2026 and on 4/3/2026, the interim order is not extended. And on 4/3/2026, there is no representation on behalf of the petitioner. Today, land counsel appearing for the petitioner submits that he has no instructions to appear on behalf of the instructions to. He has no instructions.
No instructions. Sir. On the last date, what rule is decided? I should file a retirement memo, but
it is submitted that he has already given up the
no,
file.
it was supposed to be filed, but none of conditions filed the retirement memo, so the matter will be disposed of. There's no. We have continuously tried to call the client.
What is that?
We have continuously tried to call the client to seek
He
instructions, but
submitted that
he
they
has
tried to
not responded.
They tried to contact the client and to find out about the status of the to get instructions, and in spite of their best efforts, they could not contact the client. It appears that the petition is not interested to pursue the matter. Accordingly, dismissed. Yes, 11.
11, Ramesh N.
This is a repetition of 2022. On 12/4/2022, an order of stay was granted on condition. Later, when the matter came up on 4/3, as there is no representation, the matter was directed to be listed today and the caption is the same. As there is no representation, same order in all, no representation. It appears that he is not interested. Dismissed. Yes, 12.
12, Sukanya.
What happened in this?
It's section 14 order was in challenge. Interim order was granted, it was complied, but since thereafter no payment is forthcoming.
This writ petition of 2022, where a writ petition is filed questioning the order passed to the magistrate under section 14 of the Surface Act. An interim order was passed on 22/7/2022, directing the petitioner to pay an amount of rupees 5 lakhs before the respondent bank within 2 weeks. It is submitted by the land council appearing for the respondent. That said order is complied with by the petitioner. The outstanding amount is?
20 lakhs.
The outstanding amount is 20 lakhs. It is submitted that thereafter no amount is paid. When this matter came up on 4/3/2026, there was no representation on behalf of the petitioner. This matter was directed to be listed for dismissal today. Today also there is no representation. Same, that is not interested to dismiss for non-prosecution.
Kiran Mohan.
I'm referring for the respondent number 2 in this matter. Respondent number 2, not for the bank, for the KIDP actually.
Yes. Interim order is complied with?
My lord, the account is transferred from other branch,
Huh?
my lord. No instructions from the bank. No instructions from the bank, my lord.
The,
Account is transferred from
this is a writ petition of 2022. On 4/3/2026, as there is no representation. The matter is listed today under the caption dismissal. Today also, no representation. Dismissed. Yes,
14,
next.
Armugam.
In this case, I have given NOC a year back. They have not filed the other Avakalata alternative. So I have seen it from the, this one.
Where did you
net
file the
that came.
memo in that regard?
They are having many cases. It is not one. There are 4, 5 cases are there.
There is
Other
a
case,
procedure,
there
you
is
have to file a retirement memo.
So my NOC may be taken. No
Won't be
objection I
taken
have
like
given.
that. There is a procedure to file a retirement memo saying that I've given so and so at what date, what happened to that. It is submitted with the land council, the petitioner that he has given a wakalat. This is matter on Wednesday. By the time the retirement memo shall be placed on record. Yes.
15, K. Shishikant Prasad.
This is a writ petition of 2022.
Interim order is dated 39.
It was complied. An interim order was granted on 39/2022. Land council for the respondent submits that the interim order is not complied with. Then when the matter came up on 4/3/2026, as there is no representation, the matter was directed to be listed today under caption for dismissal. Today also there is no representation. Same. Next.
16, Ankit S. Reddy.
I appeal for the respondent number 1, madam, the Union of
Hmm?
Union of India.
Union of India. It's a writ petition of 2022 on 6/10/2022. An interim order was passed directing the petitioner to deposit 13.5 lakhs on or before 51/2023. Thereafter, the matter has come up on 4/3. Same, no representation. Today also no representation. Yes, next. 17.
In this matter, you have challenged IA, order passed on IA, but the whole essay is dismissed, so the WP stands instructions.
It is submitted that the present writ petition is filed questioning an order passed on IA number IA 1464 of 2020 in essay number 417 of 2020. It is submitted that the main essay itself is disposed of. It's nothing surprise for consideration in this writ petition. Accordingly dismissed as instructions. Yes, next.
18, V. Rajaya.
This is a petition of 2022. The interim order was granted by a coordinate bench of this court on 29/11/2022. After that, this matter came up on 10/12/2025. On that day, the time was sought. This court has passed an order. No further time will be granted. Then it came up on 16/12/2025. Again, on request, the matter was posted after winter vacation. Again, the matter came up on 4/3/2026. As there was no representation on behalf of the petitioner, the matter was directed to be listed for dismissal.
This is appearing for respondent bank, my lordship.
That's
Kindly
also
note my presence.
accordingly dismissed for non-prosecute. Has he complied with the order?
No, my lordship.
It is submitted with the land counsel to the respondent that the interim order is not complied with. Yes, next.
19 withdrawn,
That's
20,
all, my lordship.
Kavita D.
Where is the withdrawal memo?
In the case of, filed a memo of withdrawal on 19/11/24, your lordship.
Memo is filed stating that the petitioner is not interested to for prosecute the writ petition. Hence, the same may be dismissed as withdrawn. Accordingly, memo is taken on record and dismissed as withdrawn. Is 21.
Grateful.
21, Giridhar H.
For the petitioner.
Bank.
Fact, the office objection has been complied with.
Yes.
The petitioner is before your lordship on three equations. One is regarding the classification of the account of the petitioner as NPA has not been with regard to the provision RBI guidelines, and the bank has classified the petition as a willful defaulter. Third one is the bank has withdrawn the acceptance of the one-time settlement by themselves, stating that it is not properly communicated. May I take your lordship to the annexure BX in volume number 2, my lord. This is regarding one-time settlement, my lord.
You filed your objection?
Yes, they have filed the objection.
First,
My
let
lord.
us look at your prayer.
My lord,
Declaring the account of the petitioner as non-performing asset based on the record of recovery in the account of the petitioner. Asset classification provision and other related matters. To remove the petitioner from the list of willful defaulters.
yes, ma'am.
In terms of annexure N1 master circular. Writ of mandamus directed to receive from the petitioner a sum of rupees so and so with interest up to 31/3 towards settlement of the. How can there be a mandamus of this nature?
Why? Because they accepted as a BX annexure. They accepted my offer of one-time settlement for amount of 36,47,000, and I tendered my payment also. They did not receive it. Then later they came up with say that no, it cannot be accepted.
Why? Why is that?
That is not OTS, your lordship.
Huh?
That is not OTS, sir. And they did not pay within 7 days.
No. There was a proposal of OTS?
No, they said this much amount is overdue. That is.
May I take your lordship to the BX annexure BX, my lord?
That is what your lordship may kindly page for 432.
Page number?
432.
4/3 of which volume?
Second volume.
Give the other volume. Second volume.
Yes, ma'am.
There is no 4/3 in second volume.
432.
Second volume starts with some 318. In between there is
432.
432, ma'am.
432.
BX, ma'am.
BX.
My lord, may I? May I please?
Yes.
With reference to your loan with us, Mangalore Candle Garden Branch, account number so and so against the security of so and so, we point out that the account has become irregular due to non-payment of EMI non-renewal. We regret that no step have been so far taken by you to separate the irregularity. Under the circumstances, we are unable to permit continuation of the aforesaid account. The account shows a debit balance of rupees.
This is not a one-time settlement.
That is what.
My
we
lord,
are-
my submission would be why it is not one-time settlement. I will, because this is the one of the series of the correspondence regarding the one-time settlement. In fact, the previous correspondence starting from the one-time settlement would throw the light whether this was accepted as a one-time settlement.
One-time settlement, they will not say pay within 7 days.
No, they have not stated so.
They said so, it's within 7 days.
Yes, my lord. Let me read further. The account shows a debit balance of rupees 36,47,418.58 as on 31/3/2023 with interest calculated up to 31/3/2023. We request you to pay the aforesaid amount. Aforesaid amount, they are specific. They have not stated that some more amount is due to be paid.
They said whatever is the due, you pay it.
Yes, my lord, that's what I did. In fact,
That is not called one-time settlement.
my lord, the next annexure,
Your lordship, as well.
my lord, next annexure makes out very clear, my lord.
Because so much amount is due, we are unable to.
Hello, on the new submission, non-submission.
Mari.
It's okay. Yes.
My lord, sorry, my lord, this is the may I read further, my lord, in the annexure BX, my lord. It will throw the clear picture, my lord, not otherwise.
No, this letter is dated.
Dated 28/4/2023.
You
My
go
lord,
on, you go on 15/5/2023, that is after 20 days.
no, my lord, 15/5, I have received on 13/5. I received this letter on 13/5. I have stated on when I received it. Immediately I approached the bank. I have produced the envelope also, wherein I received it.
Then after that, what happened?
What happened is then I tendered my amount by way of check. That was not accepted as per annexure BZ.
Yes, I have seen that.
BZ.
Yes,
My lord, then check is annexure CA, my lord.
yes.
Then what again on 22/5 I write a letter indicating that they have not received the amount and they have not accepted the amount. Then they come with the reply. That is the next annexure is regarding the notice of taking peaceful possession of the mortgage property. My lord, the page number 443. Annexure CD, withdrawal of our earlier letter. They don't say anything. They say earlier letter. Our demand notice dated 28/4/2023. Now they say it is a demand notice. Assume so for the sake of it is a demand notice means when I tender that amount, they should have accepted it. It is not their case. There was a delay in making payment. It is not their case that it is a only demand. Nowhere it is stated.
1 minute. No, after this, when you wanted him to pay that amount, he has immediately communicated to you and he said he is ready to pay. What has happened from 23 to this letter dated, this notice dated 17/5/2023? Why did you issue this notice? When he is ready to pay the amount, whatever you have said, why should you take possession of the property?
Your lordship, in annexure BX also, what we have said is, we are unable to permit the continuation of the aforesaid account. Only we will make it NPA as well. That was not That the amount was not given to him, given to the
No,
petitioner
no.
as a one-time
No, no,
settlement. This
one
amount,
day,
we are
no,
going to
no.
accept the final
In
settlement.
one
Final-
letter,
final
one
under it.
minute, one letter you said, you please pay the outstanding amount of 33 lakhs and not within 7 days.
That is only to make the account regular. It is irregular.
Then that is what it is. Now you are going to make it regular only. Then why did you deny it again? When he's ready to pay, when bank wants that,
Because in his letters, he has interpreted as one-time settlement amount.
then you say that it is not one-time settlement, it is about regularizing the account. That will serve the purpose. Why should you again say, I will take possession of the property and all when he is ready to pay the amount to regularize, then you should tell that amount is for regularizing the account, not for a one-time settlement.
Because we never said, yeah, I got your lordship point, but we never said it is a one-time settlement amount.
No, that I can see that it is not a one-time settlement. Outstanding due is so and so,
but even
you
today
pay
you are-
it.
even
No,
today-
he is ready to pay that amount. Why you are not accepting?
Even today, you are not taken in position.
My lord, in fact, the last sentence is the clear picture what has transpired on that day. We have full confidence you will be good enough to settle the account. Not regularize.
We will not go into all those aspects, whether it is a one-time settlement, it is outstanding. Now you are ready to pay you want to regularize the account. If for regularizing the account, so and so is the amount, you pay and regularize.
Already I have deposited that amount. More than that, I have deposited.
And as far as the one-time settlement and all, that is not within the domain of this court.
My lord, I am not on a question. If it is their own say that you settle the
They don't
account.
say that. They don't
No,
say that.
they say that enough to settle the account within the aforesaid time, and we will.
We will not understand it from that word. They have already
Why not?
said in the earlier letter that the outstanding due is that you have to regularize the account by paying that amount.
No, they don't say so in that letter, my lord.
If that is your contention, if it is the only contention, I will answer to that.
No, it is not only that contention, my lord. The other contention is regarding the treating of classifying the account as NPA, because RBI's clear guidelines is that after 90 days, the account can be classified as NPA. As per the guidelines issued by the RBI, they should have wait for 90 days. Then they should have issued they should have classified it. What has transpired in this case is initially the petitioner approached this honorable court, and this honorable court was pleased to permit me to regularize the account. I regularized the account. Then within 30 days of intimating me to operate the account, they classified it as a NPA. And within 15 days, they invoked the SARFAESI Act and the Recovery of Debts Act, and they initiated the proceeding. Then at the same stretch, they treated me as a willful defaulter. Even for willful defaulter, there are the how it can be deemed as a willful defaulter. The RBI guidelines is there. They have not referred the matter to the committee as which is required to pass give a cause notice, then pass an order as a willful defaulter. What happened is once I become a willful defaulter as per the banking norm, then I cannot get any financial assistance from other bank also. My doors will be closed for permanently till that willful defaulter is there, and they did not do so. Now orally they say that we cannot accept the offer of one-time settlement below the outstanding amount because you are the willful defaulter. They don't communicate in writing. Even yesterday they informed the petitioner that you settle the amount. Now they say I can't have it.
Where are the proceedings to show that you are treated as a willful defaulter?
Yes, there is.
Page number.
My lord. annexure.
This is matter on Wednesday. Wednesday,
Next Wednesday.
yes.
Much.
22, Yashwantel.
Yes. Canara Bank, who appears?
Canara Bank,
Who is,
Nandish Patil.
Mr. Vignesh Shetty is directed to take notice on behalf of the respondent bank. No representation on behalf of the petitioner. List this matter for dismissal on Tuesday. Take the court bundle and see what it is and get instructions.
23, Guru Prasad.
For dismissal tomorrow, 24,
24, Sandhya U Prabhu.
same on.
Your Lordship, my counsel is unwell today and won't be able to attend the matter. I request you to grant adjourn it to another.
What do you say?
It's the same matter, my lord, where my lord, they're entitled for some interest. When I sold a property and my lord directed me to my lord furnish the details, what is the money which you are, that I furnish the details before this honorable court. They're supposed to file objection if any.
Let's the matter on next Thursday.
Great.
At the request of front counsel, the petitioner.
Great.
25.
25, Naveed Ahmed.
As per the direction, Lord, they have filed an affidavit stating that, Lords, the OTS, Lord, we have paid. Lords, the affidavit, what they say, Lords, kindly see paragraph number, Lords, the affidavit. Paragraph number 8.
1 minute.
Lords, having accepted the OTS, Lord, they are not giving, Lords, the delivering the original documents. May I read paragraph 8, my lord? My lord, there are 3 accounts, my lord. The OTS proposal was in respect of cash credit to 2 loan accounts. That was closed. One account is GECL account that clearly mentioned, my lord, in that 7,95,156 was outstanding. Even in our communication, my lord, kindly see annexure E, my lord, along with affidavit, page number 15. You have clearly mentioned, my
So
lord.
unless that is clear, you will not give the.
No, once they settle, because GECL will not coming under the ODS scheme, my lord. It was given at the time of COVID to meet the overhead expenses.
No. A particular property is mortgaged in respect of the loan obtained from which account?
It's
For all the
connected to
three
all 3 accounts, my lord. It connected to all 3 accounts. The thing is, the petitioner is neither the borrower nor the guarantor, and there was no communication from their end stating that return the original documents as per the court order. Only they have filed this writ petition. Before that, there is no communication from their end. My lord, kindly see the annexure E, my lord, along with the affidavit. I'll just read out that. With reference to the above, this is to communicate to you that the competent authority has instructed us to collect the entire dues of GECL's account, that is number 688282537, as per the circular so and so. Therefore, we call upon you to kindly remit rupees 6,80,000.
When did you send that communication?
On 25/11/2022.
To whom you have sent?
To the borrower. Lord, this is not at all communicated to the petitioner, Lords.
There
Neither
is a
to the
signature,
borrower.
No.
No, my lord. It has been created by the Lord. Yes, my lord.
Now they say that outstanding is 7 lakhs. unless you pay that amount, that cannot be given.
Lords, what prevented them to say, Lords, at the time when OTS was not disclosed, they had never ever whispered that GECL account was pending. That's only when, Lords, after they filed the petition, Lords, they come up with this letter. This letter was not yet communicated to the petitioner nor the borrower.
Communicated.
Communicated, my lord. Authority is there.
Now he has given.
Lords,
Signature is
He has
there.
given a copy of it.
Lords, kindly see, Lord, they signed themselves. Lords, I have not
signature,
signed this. I have not signed this.
my lord.
Lord, what is the way inside?
You'll acknowledge it.
Lord, at least they have sent me by RPID, at least by email.
What do you want the court to do now?
Lords, direct them, Lords, to release my Lords.
Why will the court do it when then an outstanding amount is pending?
Lords, as
And
on
they
today.
can't do it. And
Lords,
they can't do it. Court
Lords,
will not
I will
direct.
file perjury against them, Lords, for having done this, Lords.
Do it.
This is, Lords, Lords, kindly, Lords,
You can do
grant me a week's accommodation, Lords. I'll file, Lords, necessary application, Lords,
Yes.
for perjury.
Is this matter on 12th of March?
Double it.
Serial number 26, Rajendra. May Rajendra, serial number 26.
In this matter, I appear for, there are two petitions tagged. One of the matters I appear.
Is Mr. Counsel ready?
Yes, sir.
Huh?
Lordship, we are ready.
Yes. What is the writ petition about?
Lordship, I want to share one synopsis of
Take
arguments.
that. Yes.
It fails on at least 5-6 points. That is why I made a synopsis.
Your Lordship, we are challenging that they have.
There are two writ petitions.
Yes, Your Lordship.
What is the first writ petition? 13563.
13563. Lordship, in this, we are challenging the assignment agreement dated 1/10/2020. As they have not paid the stamp duty in Karnataka. The asset and liabilities are in Karnataka, situated in Karnataka, but they have not paid the stamp duty
Dated
according to
registered
Karnataka
before the
Stamp Act.
office of the sub-registrar. Estimate stamp duty. How are you concerned?
Well, Your Lordship, according to judgment
No,
passed
how
by.
are you concerned?
Yes, Lordship.
That is a problem of the registrar of stamps and registration.
If the assignment agreement is set aside, if it's null and void, then the proceedings taken against us are set to be aside. If the assignment agreement itself is null and void, then every proceeding they have taken against us is null and void. That's how.
Yes. Yes, what is your submission?
Lordship, their contention is that IndusInd Bank Limited has assigned the account to CFM ARC. I'm concerned for CFM ARC. Now, CFM ARC, when it is assigned, what they are saying is the property is situated in Bangalore, Karnataka. Now, why stamp duty is not paid in Karnataka is the one question they are raising. Another question they are raising is why it is not registered in Karnataka. Now, both these questions I can answer very well. Their major point is that stamp duty is not paid. As per section 19 of the Karnataka Stamp Act, whatever higher stamp duty is payable, I have to remit in Karnataka. Stamp duty paid in Maharashtra at the time of registration was rupees 1 lakh. 1 lakh has already been paid. Stamp duty payable as per Article 26 of Karnataka Stamp Duty Act, Article 26 is 1 lakh. So there is no higher duty payable here. So the question of paying stamp duty in Karnataka does not arise at all. One more, their entire case is based on, they have produced also, they have mentioned that case number, case details also in the writ petition, that is Veena Textiles case. In Veena Textiles case, what has it is by Honorable High Court of Madras. In that case, what has happened is, the judgment says 28 under 28B of the Tamil Nadu Registration Act, as amended applicable to Tamil Nadu, state of Tamil Nadu, any property situated outside, I mean inside Tamil Nadu, the registration has to happen. Whereas under the Karnataka Registration Act, if there are properties in the registration, whatever assignment deed or sale deed, whatever, it concerns properties outside of in another state. So wherever portions or any of the properties which are subject matter of the sale deed or assignment deed is situated. So as far as this assignment deed is concerned, there are so many properties which are scattered all over India. One of the property is in Maharashtra, so it is registered in Maharashtra. So 28B does not help in Karnataka because such as that is peculiar to Tamil Nadu Act. It is not amended. Lordship, I'll produce the
Let's see this 26 you're saying.
28B of the Registration Act. Veena Textile Judgment I'm producing.
Take that. Registration Act.
Lordship, in Veena Textiles, kindly come to page number 14.
No, let us see the-
para number 14. Lordship.
Let us see the provision of the Karnataka Act.
That I'll come to, Lordship. I have this one.
We'll see that.
Tamil Nadu also I have, I'll produce.
No, but that is irrelevant for us now.
Yes, Lordship.
We'll look at Karnataka Registration Act.
Registration Act. Central Act, Karnataka Manual. I can produce, Lordship.
Take that book.
Sir.
We have the roster of stamps and registrations. We should keep it. Yes.
28B Karnatakaದಲ್ಲಿ applicable under amendment ಆಗ್ಲಿಲ್ಲ. I mean, I'm sorry. 28B is not included in Karnataka Act, in the Registration Act, because 28B was introduced in Tamil Nadu as amended in 1997. What they are saying is, if any the property is situated in Tamil Nadu, no registration, even GPA, General Power of Attorney also cannot be.
What is the provision under the Registration Act?
Reciprocating provision is 28.
Not reciprocating provision. You are saying about that it has to be on the value of the property or something you are referring to.
Yes, Lordship.
That is 28.
28B of the Tamil Nadu Act.
What is the corresponding provision?
28.
28?
There is no A and B.
Yes, please
Lordship,
read the place of registration documents relating to land. Subsection 2. Movable property.
Once I take Lordship through the judgment, it will be clear. Para 14 of the judgment which I have just passed on.
Actually, I have dealt with the case of that nature. That's why I'm
Yes,
asking. Let's forget about Madras. What does the Madras Registration Act say? Now, in particular assignment deed, the properties are pertaining to several, as you said,
Several.
scattered around the entire country.
Country.
So you have registered at one place. One property belongs to Karnataka. So how it was dealt with? Which provision deals with it?
28 only, Lordship. 28.
28. I don't think it doesn't say anything.
Lordship, I'll just read it. Put
It is 29.
29. Lordship. 28 and 29 maybe.
Document to and section or a copy may be presented for registration either in the office of document was executed in the office of so which the person executing claiming of the document same to be registered. There is
Lordship, it
another
says,
provision for this.
Lordship, this is only provision. Shall be presented for registration in the office of the sub-registrar within whose sub-district the whole or some portion of the property to which such document relates to is situated. Now, it doesn't make a differentiation between properties within Karnataka and outside Karnataka. '29 is a subsection of 28, Lordship. It will not affect here.
Then where about the registration charges and the stamp duty on that?
That is, that will come to Lordship. Now, let me complete this particular judgment, which says, kindly come to page number, para number 13.
Which I'm not able, what I'm not able to understand is, he's relying on some provision of act. And basing on that, why should we go into that? He should say, what is it in Karnataka?
That he has to tell.
So for that, we don't have to go into the judgment.
Yes,
Now you have to tell the court, as you are submitting, 1 lakh you have paid there, that is on the higher side. So where does it deal with the charges?
19, section 19 of the Stamp Act.
Yes.
If Lordship considers their prayer, they only say stamp duty is not paid. Registration, they are not dealing with.
Section?
So section 19, Lordship. Stamp Act.
Yes, I'm looking at it. Yes.
Payment of duty on certain instruments liable to increase duty in the state of Karnataka, where any instrument of the nature described in any article in the schedule and relating to any property situated or any matter or thing done or to be done in the state of Karnataka is executed out of the state and subsequently received in the state, the amount of duty chargeable on such instrument shall be the amount of duty chargeable under the schedule on a document of the like description executed in the state of Karnataka, less the amount of duty, if any, already paid on such instrument in any other state. So 1 lakh I have already paid there.
So what is the?
I don't have to pay anything, Lordship. That's what.
What is the duty payable in state of Karnataka?
26, Lordship, article.
26? Yes.
Article 26.
Yes.
I'll read it, Lordship. If relating to assignment of receivables by the originator to the special purpose vehicle or by whatever name they are called in the process of securitization under the Act, 1 rupee for every 1,000 rupees or part thereof, subject to a maximum of.
I'm looking at Article 26.
26, 20 subsection.
Yes.
Subarticle 6.
Yes.
1 rupee for every 1,000 rupees or part thereof, subject to a maximum of rupees 1 lakh.
Assignment of receivables by the originator to the special purpose vehicle, whatever name they are called in the process.
Specifically for SURFACE Act.
Where do you get that, 5%? Where do you get that?
Not 5%, Lordship. 1 rupee for every 1,000 rupees. That will work out to be 0.1%.
5% of consideration of the market value of the property, whichever is higher.
That may be subsequent amendment, Lordship. I mean, we have to look at 2019 because that was the date when it was executed.
An amount equal to the 5% of the aggregate value.
Which amendment, Lordship? Which year the Lordship are looking at? That is not there in 19 Act.
It is 20. It's the latest one.
Latest one. So it is as far as this case is concerned, the document was executed in 2020, 1/10/2020. So the Act as on 2019 would apply. So this is 2019. It doesn't contain that particular subclause.
Rupee for every 1,000 rupees. What is the value of the property?
Property value could be around 5 crores or 10 crores.
Mm.
I don't know.
Mm.
Above 5 crores.
Mm.
But the maximum stamp duty is
Maximum rupees 1 lakh.
1 lakh.
Mm. So according to you, as you have paid already 1 lakh.
Already that 1
You
lakh.
need not pay in here.
Yes, Lord.
Mm. Yes.
But Lordship, according to the judgment that we are relying, if the assets
You
and
have to,
liabilities
you have to rely on
situated-
the judgment which applies to the state of Karnataka. And when there are specific, the act and rules are there.
Then your Lordship,
You can't rely on
when-
the Madras Stamp Act and rules.
But Lordship, they have even registered the same thing in Mumbai. They have not registered in Karnataka. Even
What is-
they have not even, what the act says that subsequently it has to be endorsed in Karnataka. That also has not been done by them.
It's not done.
It is not required, Lord, as per.
Right.
But it is
No, not
required.
required. I'll come to that.
We
I'll
are
come to
only,
that.
we are only on the point of paying the stamp duty and registration.
Lordship, I'll come
Then
to
it
that.
has-
I'll produce certain judgments which will cover that, those points.
Yes, where is that judgment?
I am producing, Lordship. Lordship, first of all, Reserve Bank of India, I am producing Master Direction, Reserve Bank of India, Transfer of Loan Exposure Direction 2021. I have only one copy, Lordship. I'll just read through it and then I'll try give it to the court.
Also give him the copies of it, what you're relying on.
I'm not, see, this is an act, Lordship.
No, whatever you're relying on, give him a copy of it. He should also know.
I'm having, this document already they have relied on. That is why I'm not.
Give all those judgments also to him. Let him also prepare. List this matter on 10th.
10th, Lordship.
Give all those, whatever judgments
Absolutely,
and
I'll
all,
do
so
that.
that he'll
I'll
have
do
the
that.
benefit of reading it.
27.
A synopsis, no, file matter.
Dana?
Yes.
My lord, regarding respond number 1 and 2, I'm filing one memo to dispense with the service, my lord, because they are not.
1 and 2.
They are not
required.
relevant parties.
Take that.
And the matter may be heard. And when
Memo is
that,
filed.
my prayer is,
Dispensation of notice to 1 and 2. It is stated that they are not necessary parties. Accordingly, the memo is taken on record and notice to 1 and 2 is dispensed with at the risk of appellant. Yes, what about,
So 2 is a necessary party.
huh?
Who is the necessary party? Because he has executed the sale agreement in favor of respondent
Third
number 3.
respondent.
government is only necessary party, my like, prayer is against the government, this is sub-registrar's office.
So he is seeking for deletion of the entry in the encumbrance certificate made in May 5.
Well, let us see, what is this,
My prayer, your lordship may kindly see the prayer, my lord.
My lord, may I
Yes.
request, my lord, I have filed power on behalf of respondent number 3 on 3rd of March. My name is not shown today.
1 minute, let me just look at.
Please.
Prayer, my lord, page number 12 of the writ petition.
What is the procedure under the act?
You have to get it cancelled, my lord. Agreement has to be cancelled because
They
it is a registered agreement, no? Entered
Uh.
between the respondent number 2 and 3,
My lord, this
And
mortgage,
unless, my lord, it is cancelled, my
My
lord,
lord,
the entries cannot be removed, my lord.
this
You have
mortgage
to
is
approach the court.
2013. And this agreement is 2015. Mortgage of the property, the entire property is mortgaged to the bank for, and security interest has been created. Now, the property was sold. And after selling the property, that party action purchaser came that because of this entry and all these, I am unable to get any loan to pay the money, hence I don't want the property.
A particular
honorable court-
document, a particular document is registered. Once it is registered in the encumbrance, it would be shown.
No, that is my.
Why would a high court
my-
direct the stamp, the department
No,
to
I'm not
delete it?
telling, my lord, that is two alternatively, as decided by many courts, judgment also produced, a contra entry can be made. That, my lord, one judgment I'm producing, my lord, where the.
Go before the DRT and seek all this.
No, DRT cannot do, my lord, the only under high court only have to do, whether to make the contra, that they.
He has to file a suit under section 31 of the specific relief act. for
Even
seeking
if it is
cancellation
not
of the-
permitted to delete, but
Registered
contra entry can be made, that is as held by the courts. You are telling that the deletion, it may not be possible.
They tell that a bank is having a first charge and all.
No. That and all is submitted, my lord.
After alternative prayer, I am looking at alternatively make a contra entry
Entry, yes, my lord.
stating that the bank is having priority and first charge on the mortgage property is as per section so and so of the
26C.
Success Act.
No, my lord, that is what, your lordship kindly see on judgment, my lord. This is, the judgment is clearly mentioned, my lord. That I will read, I will give the copy of the judgment. What it says, my lord. This, after having rival contention, this court had given the anxious consideration. In the present case, the mortgage of the bank is in the year 2015. Here we are in 2013. And the arbitration award is in 2022. Hence, the mortgage is prior to the arbitration award. But in 2022, arbitration award was registered. The crucial question is that whether the registration authority has power to delete the arbitration award entry based on the bank's representation. As rightly contended by the Additional Advocate General, and power is not granted to the sub-registrar. In the judgment referred in so and so, it has been held that any mandamus would not be against the statutory provisions. It is seen that the same was dealt with by another coordinated bench, so and so, when the court held that there is no provision in the Registration Act which permit the authorities to delete the entry. Further, held that as customary practice, the registrar is bound to cause contra entry, stating that the earlier entry stands raised in view of the exercise of the priority right over the petitioner's bank. Even in the present case, the sub-registrar ought to be directed to make contra entry and accordingly directed to make contra entry. Because now otherwise, what will happen, my lord? This is sale agreement registered. Now the mortgage has been created earlier to that. Even as per Surface Act 26C, bank has priority over that matter. That is why it is not possible to delete it. But contra entry can be made. That is what these honorable high courts have held. That is one, that contra entry, that is not going to make it. The contra entry has to be made. If the contract is made, then in any case, the bank can sell the property.
No,
Otherwise,
no,
the bank cannot sell the property at all for long.
No, let us say that is not made. What will happen?
No, you cannot sell the property. Now that person, that earlier sale was conducted. Now that bank has refunded the amount as directed by the court. Now, if the contra entry is made, again they can sell the property.
No, the registration authorities will tell that the bank is having the right over the property. What is the duty of the registration department to say all this?
That is why wherever this, under that circumstance only these judgments have come, my lord. Because if it is not mentioned now, for example, the bank, that means money has got lost. They cannot sell the property at all.
Let's not tell them too many things which they are not supposed to do.
My lord, this is judgment. It is not.
Maybe that may be.
That it may be taken up tomorrow. Another Supreme Court judgment is also there. That also produced, my lord. Because now if it is not done, the bank will not get the money. Then how to get the money now? Now we are the first mortgager. We have got the right, as per the act that says that we have got the right.
How to get that document set aside?
No, we are not deleting it. Contra entry has to make it. That means that entry is also there.
Will not tell. If you're relying on any Supreme Court judgment, you please rely on. I'll consider and pass orders. This is matter on.
Start date may be because this
matter on 13th of March.
Yes, ma'am.
Yes. 2 weeks time, kindly be because
let
me file my objection.
He is a petitioner. If you want to
I'm a
file
bona fide purchaser for a value loan. They have not registered the mortgage. It is only deposit of title.
The court is saying that now to write all that. Court will pass an order. If it is in your favor, fine. If it is not in your favor, you can file an appeal.
Please.
Yes. Yes, next.
28, seal number. Gopal Krishnamurthy.
Yes.
Please, respect of respondent number 3, notice is awaited.
Who is respondent number 3? What is the prayer?
Prayer regarding that.
You are questioning an order passed under section 14. On what ground?
On the ground that, my lord, we have paid the 75 lakhs and we are ready to pay even the action process charges because, my lord, in the month of November 2025, so that action took place, my lord. We are ready to pay that amount for the subsequent purchase or even action purpose, including interest also we are ready, my lord. Only 26 lakhs were due. We have paid the 75 lakhs. That is our request, my lord. Because it is a resident, by that time, my lord, it was a vacant site. Later we have built the building.
No, already auction is done.
Correct, but my lord,
how can the court set aside the auction?
By that time 75 lakhs we have paid, my lord. But
whatever it is,
at
as
the
you
two
know,
properties, my lord.
We can't set aside the sale.
Because my lord, Ashmi kindly appreciate whatever they have, my lord, assessed that amount. my lord, means barring that, my lord, we have paid the amount. Only for 45 lakhs, they have sold the property, my lord.
Tell me something legally.
My lord, because my lord, they have valued the property and even the stamp duty also. So they have assessed, we have assessed the stamp duty for the purpose of industry. But my lord, they have assessed the land value for the purpose of the residential.
But the section 14, all these issues can be agitated before the DRT.
My lord, since my lord, we are ready to pay that amount for 26 lakhs
Cannot.
and we
This
have built
court
the
cannot,
building.
this court cannot pass an order setting aside the auction unless and until there is an irregularity in the auction. And the court cannot say, you please, will set aside and let this money be taken and
Because my lord, by that time, what,
let the property be,
and moreover, my lord, the
mortgage be redeemed in
the
favor
main
of the petitioner.
ground is, my lord, the recently Honorable Supreme Court has taken a view. My lord, there was a dispute between these persons before the the bank, my lord, wherein, my lord, their claim petition was dismissed. My lord, by suppressing that fact, they have filed the criminal miscellaneous and they have mortgaged this property. My lord, the Honorable Supreme Court has taken the view that suppose if they suppress bank, yes, if they suppress material facts regarding the pendency of any proceedings, subsequently, my lord, if they sell the property without disclosing that, that amounts to fraud, my lord. That is the view taken by the Honorable Supreme Court very recently. That they have done it, my lord. Kindly see, my lord, we have produced the
Why this fraud, the
entire order sheet itself we have produced,
DRT
my lord.
can't decide the fraud.
Please, my lord.
DRT can't decide the fraud under section 4.
My lord, between that, my lord, we have approached the DRT, but my lord, the SA, since the sale was, means the subsequent bidder was not present, so that has become infructuous, my lord. Later, my lord,
Come here, why you should have gone there.
between that, my lord, what has happened, my lord, in the month of October and November.
Now this is high time that we should stop this practice of entertaining the petitions under DRT and granting interim orders, keeping the matters pending for, now I've seen matters.
Please.
2016 interim order pending till 2026. And what is the purpose of this Securitization Act? Establishing the tribunals. When High Court can do it, why should we unnecessarily?
But
Because this is not a case.
my lord, because my lord, it's very good ground, my lord, because they have suppressed that fact
That
and
is
they
a
have taken
good
the order
ground. If that
behind
is
the
a
back
good
of the
ground,
petitioners, my
DRT
lord.
will decide it.
My lord, till today, my lord, though you have taken the ground, my lord, they are not ready to even file objections also regarding that. They have and it is on record, my lord, we have produced the certified copy of the order sheet also.
If any disputed questions have to be proved, you will get an opportunity before the DRT, which is not possible before this court. So why should we keep these matters unnecessarily pending? If you have an interim order in this, I will protect it for 4 weeks. Till in
No,
the
my lord,
meantime,
interim
you
order
approach.
was not there because,
Then you go, then all the more reason you have to go.
but
Let
because, my lord,
the
now
DRT decide. DRT decide.
subsequent to the purchase of, my lord, is now, you know,
We
one
can't
person
set,
is served.
when you know about the law of the Honorable Apex Court,
Yes,
you know what are the other, what are the other line of
My lord,
judgment?
the entire sale proceedings itself is quashed, my lord, by the Honorable Supreme Court.
Quashed, that the
Because,
DRT can
my lord,
do.
they are not ready
When
even,
you have a remedy before DRT, you need not come before the court.
my lord, they are not ready to even deny that fact, my lord. They themselves have not produced the
Found the
document.
present writ petition is filed seeking the following prayer. Land council submits that the bank has committed fraud. And certain important, the crucial aspects were suppressed before the magistrate and obtained an order as such he has come before this court. Next para. Whatever the contention that are raised before this court, the petitioner can as well raise before the DRT. And it is not the case of the petitioner that the DRT cannot decide. In fact, the petitioner would be in a better position if necessary to adduce evidence before the DRT and any disputed questions of fact. This court cannot decide in that view of the matter. This court is passing the following order. Writ petition is disposed of giving liberty to the petitioner to avail the appropriate remedy before the DRT. And the petitioner shall have the benefit of section 14 of the Limitation Act.
Grateful.
29. Mubarak Begum.
May it please your lordship, I appeal for petitioner in this matter.
Respondent, my lords.
My lord, I
As
have
on date,
challenged
outstanding is
in this
29
matter,
lakhs.
my lord,
Let him say what he want to.
As on date, outstanding is 29 lakhs 21,678, my lords.
my lord, this matter was listed before the coordinate vacation bench on 26/12/2025, my lord. Subject to payment, I have been granted interim order of stay of 15 lakhs. My lord, to deposit and also further direction were given by the coordinate bench to deposit the original DD within 3 working days. And my lord, I have deposited the original DD on 30/12/2025, my lords. And my lord, now I came to know
I
that
think that the DD is
DD is
misplaced.
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 So direct them to place the DD, and what about the remaining amount?
My lord, remaining, in fact, my lord, I have given 3 or 4 representation voluntarily coming forward to settle the account for 12 lakhs. My lord, when my submission were placed on
Not about
record,
the 12 lakhs, whatever is outstanding, now you're paid some amount, come up with an affidavit for, with regard to the remaining amount. Then
I'll
only
seek
will, otherwise there is
instructions in
nothing in
that.
these matters to be entertained with this court.
I'll seek instructions in that regard, my
No
lord.
instructions, I'll pass an order, you file affidavit or else I'll hear the matter on the merits of it. A note is placed, an office notice placed before the court that the DD for an amount of rupees 15 lakhs, which is drawn on Union Bank of India, Madragiri branch, which is submitted to the registry by the petitioner is misplaced. Then counsel with the petitioner submits that if the time is, the petitioner will place another DD for the said amount.
My lord, placing another DD would be difficult without the original DD, my lord, unless and until there's some direction from this honorable court to the concerned bank that DD has been misplaced, either any letter, because in the absence of original DD, it is very difficult to obtain.
It is submitted by the petitioner, that there may be a direction to the bank to issue a fresh DD, considering the fact that the DD is misplaced by the office. The bank shall give the fresh DD for the very same amount, and this exercise shall be completed within a period of 10 days from today. With regard to the remaining outstanding amount, the petitioner shall file an affidavit before this court within what time the petitioner is going to pay the amount. Basing on that, further orders will be passed. Does this matter on 1st of April?
Let's let them deposit the DD directly to the bank, my lords.
Huh?
Instead of
That
placing-
amount, instead of to the petitioner, shall deposit the said DD to with the bank, respondent bank.
Bless.
30, 30.
Yes.
My lord, in this
Yes,
case, my lord, the bank has given now the sale certificate copy. I have to implement the auction purchaser, my lord. I have to implement the auction purchaser. Now they have given sale certificate copy, my lord, with the details of auction purchaser.
They have filed an appeal before.
Does this respondent compel to accept the representation permitting the petitioner to enter
Yes, my lord.
redeem the properties? What is this direction? How can you ask?
My lord, in
What
this-
is how these kind of petitions are filed with this kind of prayers?
No, my lord, only.
Whatever you wanted to go before the DRT and do.
Already essay is pending.
I have challenged sale notice, my
Go,
lord.
go there. The present petition is filed for seeking the following prayer. When the matter came up for hearing, land council submits that now the sale certificate is also issued. They will, the petitioner will implead the auction purchaser. The prayer as sought before this court is not at all maintainable. There cannot be a mandamus directing the company, respondent company to accept the representation, to settle the entire legally dischargeable amounts and to redeem the mortgage. It is submitted with the land council with the respondent that already the essay is filed before the DRT. The petition is agreed by any of the action, any of the steps that are taken by the respondent bank. The petition is at liberty to avail the appropriate remedy in accordance with law. Accordingly, the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy in accordance with law.
My lord, the benefit of limitation. my
Section
lord.
14 limitation.
Right,
31,
my lord.
Entitled for the benefit under section 14 of the limitation act. Yes, 31.
Milords, I'm for the petitioner in this case, Milords. Milords, in this case, Milords, in OA 1664 of 2017, Milords, I had filed 2 applications for cross-examination in the year 2023 and IA for production of documents. Milords, those IAs came to be dismissed on 35/2025, and Milords, page number 202 may be looked into, Milords.
Why you come before the court without going to the DRA?
Milords, 202 may be looked into, Milords. Page number 202, Milords, 202.
The first question you have to answer, why you
Milords,
have to come?
I'll just
We
point
should-
out,
we should, I am very firm on this point, we should stop this practice of
Milords,
coming to the High Court
that-
for each and every matter
Milords, that
to surface it.
Milords, that question, I mean, the answer is at page number 202, Milords.
What is
Because,
that?
Milords, in WP number 100309 of 2017, when I had challenged the legality and correctness of the OA, which was filed by respondent bank, in 2021, this honorable court, Milords, I'll read out. For all the aforesaid reasons, I am of the considered opinion that there is no merit in the writ petition. Writ petition stands dismissed. Liberty is, however, reserved to the petitioner to agitate any grounds raised in writ petition number so and so. My lords, as per this order, my lords, I had filed two IAs, that is one for cross-examination and another for production of documents, that is direction to the bank to produce so and so documents.
What is
My
the
lords,
connection
page number
between this and
191
that?
may be looked into, my lords, page
What is
number. Yes, my lords.
The court has not given any positive direction to the DRT to consider your application.
My lords, there is one more order by Honorable Apex Court, my lords, page number 191 may be looked into. My lords. Page number 191. My lords, in this case, there is a fraud committed by a bank, my lords. My lords, there is a FIR against bank officials, managing director and
But
other
I am-
office bearers
What I
as
am
well.
asking you is a different
My lords,
question. Your submission is a different.
I'll just make few submissions, my
I
lords.
am saying, why can't this order be assigned before DRAT only before the High Court? That's my simple question.
My lords, only because, my lords, if this application is allowed, my lords, the truth which has been
I am not saying anything on the merits of the matter,
Yes, my
whether
lords.
it is right or wrong. I am saying, why should you come to this court?
my lords,
Go to the DRAT. Those are the tribunals which are constituted for the specific purpose. Why are we dealing with all this? And why are you keeping the matters pending, one at DRT, one at DRAT, one at the High Court?
my lords, on that point, I'll convince you, this honorable court in the next state of hearing, if this honorable court
I will
permits
not be
me to.
convinced on that point.
My lords,
whatever you say.
I'll just point out few points, my lords. I'll just point out few points.
You
My
have
lords, in this-
101% case on merit. Let
My
us
lords,
accept it.
yes,
In
ma'am.
spite of it, why should the High Court deal with it? That's a
Lords.
simple question I'm asking. For that, there is nothing else. The only answer is you can go.
Yes, my lords, I'll convince this honorable court in the next state of hearing, my lords, if this honorable court permits. My lords, only few points, my lords, in this case. There is a FIR against respondent bank officials, managing director. My lords, my lords,
That
let
is on
me
the
let.
merits of the
my lords,
matter.
My lords, few submissions, my lords, few sir. My lords, those criminal petitions have
Why I
been.
am not listening to your submissions is ultimately whatever you submit, I am on the same point.
Yes, my
So
lord.
first you answer that point, then we will hear.
Yes, my lords, I'll convince this honorable court in the next.
On
state.
how you will convince, on
Well,
what is there to convince?
My lords, I'll get few judgments of apex court if possible.
I can give you 100 judgments right now.
Lords, I'll get it, my lords, if this honorable court.
Waste of time, please understand.
Lord, I'll-
It is neither here
I'll-
nor there. I'll have this matter tomorrow, please tomorrow.
That's not tomorrow, my lords, on Wednesday, my lords, if possible.
Yes,
Tomorrow I have
Wednesday-
some inconvenience.
Wednesday, no further adjournments. will be
My lord, we
granted.
already filed a
There is
statement.
already an interim order.
Objections are already placed. In fact, my lord, my lord, he given up this prayer before the DRT. He argued, my lord,
Let us
final
not
argument.
go into all that.
Grateful.
Let's not go into all that. Let's stop that practice. Yes.
Grateful.
Lords, interim order.
Interim order is extended till Wednesday. No further time will be granted.
Grateful.
Matter has to be argued on
Yes,
Wednesday.
yes.
Yes,
32, Sangeeta.
yes.
My lord, it's a matter. I will take notice on behalf of my respondent. DRT, my lord, I assisted in the matter.
To set aside the order dated passed by the declaratory tribunal. Same will apply to you also.
My lord, the property is undervaluedly sold, my lord.
Whatever it is, go before the DRAT, not before
My
this
lord.
court.
A short date may be given, my lord.
For what?
My lord, I have filed an application before the DRT, my lord. Seeking details of the auction purchaser and all other details relating to the same. I will convince this court, my lord. Kindly, my lord.
The court will not be convinced. I'm
My
making it
lord.
very clear. You
My lord,
have to go
kindly, my
before the
lord, next
DRAT.
week.
Please go before the DRAT. This is the high time that we should stop entertaining the petitions under surface.
My
All
lord.
routine petitions. If it makes any substantial questions of law, which the High Court has to decide, court will entertain. Not every matter, every order that is passed by the DRT, you come to the High Court. List this matter also on Wednesday, no further adjournments. The petition has an effective remedy under, effective remedy before the DRAT. The present the counsel for the petition submits that she'll make submissions on the maintainability of the writ petition before this court. Yes, 33.
Copy of the writ petition may be served upon me, my lord.
Huh?
Copy of the-
Mr. Vignesh Shetty is directed to take notice on behalf of the respondent bank. Petition shall serve with a copy of the writ petition on the council. Yes, 33.
33, Manoj.
Petition in this matter. But this matter is not challenging the OA order. On the ground, my lords, that the tribunal has exceeded its jurisdiction. My lord, there is an interim moratorium operating. The same was intimated to the bank. Even after that, suppressing the fact that the respondent bank has obtained an order.
Who appears for the respondent? Union Bank of India. Yes, Mr. Vignesh Shetty is directed to take notice. Serve him the papers. List it on Monday.
Good. Until then, my lords, there will be protection, my lords.
34.
Until then, let there be a protection, my lords.
Yes, Monday. Nothing will happen on Monday, till Monday.
Yes, Suru.
Lordship, this has a substantial question of law.
What is that?
The thing is, they have actually, they have a impugned e-action notice without completing 30 days, which is very much required. There should be a clear 30 days. So on 2nd of February, they issue the notice, and on 3rd, they auction it. So it's a very settled principles of law that the date should be excluded. Even otherwise, it doesn't complete 30 days.
Actually, the e-auction notice was sent to them on 2nd. They have very well received. Before that also, they have given a lot of representations. They have not availed any remedy before.
No,
DRT
forget
also.
about it. Whether they avail the remedy or not, you're supposed to follow the provisions of the
You are my
act.
lord. Second is
Have
was
you
the
followed or
second
not?
of the date of notice, and third is the auction. It is 30th.
When was the notice?
2nd February.
2nd February. When
Yes,
was the
madam.
auction?
3rd March.
3rd March. What was the time?
30
gap?
days.
Huh?
30th day. That was on the 30th day. 30 days including sale of date of notice. 30 days including the date of notice.
Yes.
The auction sale was on 30th day.
Lordship, the court is well aware of this, but for the benefit of argument, I'm going to read this out. Section 9 of the Security Enforcement Rules, it says, no sale of immovable property under these rules in first instance shall take place before the expiry of 30 days. So it is not within. So, and even there is a judgment, which I'll share, which clearly says there should be 30 clear days. Now, when we say 30 clear days, the day on which it is published should not be considered. And even the day of auction should be excluded because it's going to be the next day after the 30th day. So this is where I am. In spite of these, I am ready to settle on the, kindly peruse annexure. I've written an email. I'm ready to settle. I want to pay.
That settlement and all between you and the bank, that is not substantial question of law.
No.
Question of law is only this. We will only deal with it.
Yes. So here 30 days is not complete is my submission.
30 days has been
You have to
sufficient,
tell,
madam.
You will share a
you have to
judgment.
tell,
Your
now he has
Lordship.
relied on that provision and says the date of the auction, 2nd is excluded
Excluded.
and 3rd is excluded. So between 3rd
It is
and
in-
the 2nd,
I will
between
explain the short date, but yesterday we have served with the notice, caveator.
so and so, you have already filed the caveat.
Yes.
This is matter on Tuesday, no further time.
That's okay.
The respondent shall get instructions by the time. Yes, next.
35.
Publish my lordship.
Nagaland.
Move the application for the
Yes.
For the petitioner, my lords, senior counsel will be here.
Huh?
I appear for the petitioner, my lords. You've engaged the senior counsel. He will be here in the next 2 minutes, my lords. So it may be taken up
Lord's
after.
appellate court
Number
confirmed,
36.
What is the order?
Lord's appellate court under the Public Premises Evacuation Act confirmed the order of eviction. What they do, Lord's I am ITI Limited.
Yes.
Lord, there are two companies, my lord, which are public sector undertakings. I'm a transmission utility for the state. Lord, the respondent is telephone industries. Lord, historically, my lord, when they wanted to set up manufacturing unit in Bangalore, in the outskirts, my lord, at that point in time, it was outside the city of Bangalore.
on what we used to call as Old Madras Road, my lord, the road between Bangalore and Chennai. There's a plot which was allotted to them. They established their factory there. At that point in time, my lord, they wanted electricity to be supplied. And as per the existing, my lord, the 1948 onwards, my lord, there is my lord, documentation available with regard to the fact that, my lord, the property was they allotted to them and they assigned an area for us to have our equipment, etc., for the mainly for the purpose of supplying of electricity.
They have allotted.
Yes, it is, they have allotted, and that is required, my lord, as per the regulation. That was the requirement. There is a statutory, my lord, form of lease also. Unfortunately, both of us, my lord, seem to have lost that original document. But as per the regulation, there is a statutory document, my lord, like mining lease. There is a regulation provides for a statutory document under which I am supposed to get possession of a particular property for keeping my equipment and making supply. From that day till today, they are getting supply through this, my lord, establishment that I have established. Now, my lord, this establishment that I make cannot be as an island, because it has to be connected, because it has to receive power for the purpose of supply. So it is connected to the grid. Now that, my lord, this respondent seems to have stopped manufacturing, but the estate officer issues a notice under the provisions of Unauthorized Occupants Act to say that one, you pay rent for this, then you be evicted from this particular place. Is the proceedings that is initiated.
Whatever that is established there is only for the particular purpose of providing the facility to this,
Yes.
to this people.
My
To the
lord,
respondent.
originally, yes, originally, my lord, dedicated to them. Now, my lord, there are extensions from there, in the sense, my lord, it connects to other sources, other substations sources, because, my lord, it's part of a network. My lord, for the purpose of receiving energy and sending it out, I have to be connected. My lord, therefore, my lord, today it may not be completely exclusive, but originally, my lord, it was established exclusively for the purpose of well,
So now,
supplying power.
apart from their land, you're providing facility to other people also.
My lord, in the sense, my lord, power from here is supplied to other substations. My lord, similar installations which are established somewhere else. Power flows from here to some. They're all connected through the grid network. So to that extent, my lord,
But
it
the
is
fact
not a.
remains is that property belongs to them.
My lord, the property, my lord, I don't have any title document so far as that property is concerned, but my lord, the two aspects I have placed for consideration. One, my lord, in respect of such litigation, my lord, Honorable Supreme Court, my lord, looked at litigation of between government corporations, government bodies, etc., and said that this kind of litigation is something which has to be curbed, and straight away these parties should not be allowed to come before court and clog the court. And
Who is this? What is this respondent? Is it any defense organization?
no, this is a central government company, public sector company. You know,
Please, Manoj.
composition of it.
I'm sorry, we are a public sector enterprise, Manoj. I think its owned, majority ownership is of the central.
Government. I'm wholly owned by the state. Lord, this very aspect was considered, and I have taken this ground before the earlier proceedings also, to say that it is a grievance between two public sector entities, and there is a mechanism for resolving this issue. And we have, Lord, I'm also in Lord, serving the public, and this is installation that has been established is something which is not for any particular benefit of any other individual or anything of that sort. This has become part of the grid network as such. Therefore, this is an issue which has to be discussed possibly and resolved between the two entities, and that is, my lord, what the Honorable Supreme Court says in the ONGC's judgment, second ONGC judgment of 2007.
So this is going on from 2020 or 19? 2019.
19.
Lords, the first notice is of July 2018.
Hmm.
The notice under the act issued to them is of July 2018.
From then, my lord, we have been raising this issue. From the very beginning, we have raised this issue.
But there is no scope for amicably settling the
May
issue.
I place two submissions? Because I'm sorry, I have these photographs in the file. What has happened is they have established, my lords, an entire transmission unit, which they say in their pleadings becomes part of the grid on this 5 acres of land. That
What is the extent of land?
5 acres of land, my lords. That original agreement was, my lords, I'll show your lordships the language of that agreement for power supply, which they rely upon. It contemplates, my lords, that I should afford them accommodation to bring their cables, accessories, etc. onto my land to afford me power supply. Now they admit, my lords, that under that agreement, they've taken the 5 acres. And just see these photographs, my lords. They made a gated complex. They have gates there, my lords, where they have established the lordships may kindly see, my lords, that blue gate is their property now. And my lords, kindly see in the second page, they put a board which says KPTCL ITI 220 66 11 kV GIS receiving power station.
Yes.
Now, my lords, it's in this backdrop that, my lords, we issued that notice to them, the estate officer. And my lords, what happens is after they issued one notice, they appear for a meeting. And pursuant to that meeting, my lords, when repeated notices are issued, they write a letter saying there's no need to come and appear before. Then they're placed ex parte, my lords. They don't lead any evidence. Under the act, my lords, once a show cause notice is issued, they're required to show cause and then indicate whether they wish to lead evidence and want a personal hearing. They refuse to participate, my lords. And accordingly, after considering, my lords, the respondent's position, the estate officer holds that the title belongs to the respondent. They have not made out a lawful basis for having established this unit and directs them to leave, my lords, to be evicted. And, my lords, thereafter, after having refused to participate, they file an appeal. And, my lords, in that appeal, raise a ground that they were not heard. Kindly see, my lords, just see page 40 of the writ petition.
May I place my case, my lord, because
Very well.
I don't know, he's in very great enthusiasm to.
No, I was only pointing out, my lords, that they must first cross, my lords, that preliminary issue, whether having refused to participate,
No, no, I
they
have
can
not
now
refused.
litigate the issue, my lords.
I have not refused to participate.
Lords,
I
I'll
will
show that. I'll just show that one sentence, my lords. After 3 notices are issued.
You should allow him to.
No, very well, my lords. My learned senior wishes to argue, I'll wait my turn.
Yes.
Lord, I was pointing out, my lord, I passed on a judgment of the Honorable Supreme Court.
What are the efforts made by you in that regard?
My lord, I have, my lord, pointed out that this is an establishment which is.
To amicably settle the issues, what was done by the first respondent, the petitioner herein?
My lord, I have said that there is a separate committee, my lord, for this purpose. And I have, from the beginning, I have said that if this is a dispute, my lord, they want to fix a rent. And they want this, my lord, to be paid rent for the past period, etc. Therefore, my lord, I said that there is a established, by notification, they have established a committee for the very purpose.
No,
And even
when did
now-
you say so?
Huh?
When did you say so?
No, in the very beginning itself, not in the appeal also I have taken this contention that this is an issue which possibly has to be resolved in the
Committee consists of whom?
Lord committee, Lord, as on today, kindly see this notification, Lord. There are notifications earlier also because it has to be considered now. That is the notification. What is that? Committee is reference, my lord.
Who will constitute the committee?
Lord, it's constituted by the central government, Department of Public Enterprises, Ministry of Finance, for procedure and structure of the committees. At the first level tier, all the disputes shall be arbitrated upon by a committee comprising of secretaries of administrative ministries, departments to which disputing CPSEs, parties belonging to Secretary
Is the
Department of
union a
Legal.
party to this?
Lords, it's a central government corporation.
No,
PSU.
Union of India is a
No,
party to it.
No.
We'll make Union of India party,
Yes.
so that we'll pass orders.
Yes,
We'll,
ma'am.
we'll
Kindly
fix the
see, my lords.
timeline. No,
Permit
I
me to-
understand.
Let's
Without
kindly
go-
I just want to place one aspect of this memorandum. Let's kindly see in the first page. Let's, the first paragraph itself. Whereas guidelines for resolution of commercial disputes between CPSCs, inter se, and also between CPSCs and government departments, organizations were issued by the.
No, it is like this.
Lords, this is
Though
a
it is not a,
state
though it's
entity.
not a commercial dispute. Right from, when is that, 19?
48 onwards.
So from right from 1940 till now, there, the unit is established there. Now you have shown what kind of
That's true, my
arrangements they
lords. They have
have.
developed a large unit.
So amicably to settle this. Now, what are the implications if that is removed from there? We don't know.
No, my
How
lords,
have you have to be
I quite see, my
compensated?
lords. At
So
this stage, my lords,
what
may I
we'll
say
do is
this?
we'll ask them to implement the Union of India. Like, I'll take up this matter next week itself, around 11th or so. Then once the council appears, we'll ask them, we'll fix a time limit to, to decide this issue. So that you are waiting for this matter from
Lords, I
2021.
have no difficulty, my lords. The only submission I would make, my lords, is that perhaps.
It is always open
Very
to
well.
decide the matter on the merits of it, but considering the fact that
No difficulty.
it is submitted by the senior council.
We repeatedly called on them, my lords, right from the beginning, to come and sit with us and settle a rent. It was not intended to say remove the facility, because now there is a public facility. But whether it could be done on my land without any, my lords, authorization or any legal basis was the issue. But I bow down.
But you're interested for an amicable settlement there you're
Yes, ma'am.
asking.
Very well.
So that's why
Very
if the
well.
rent or something
Please.
is fixed,
Very well.
the senior council appearing for the petitioner submits that there is an office memorandum issued with the Government of India, Ministry of Finance, Department of Public Enterprises, dated 8/12/2025, whereby the disputes between the two governmental organizations or instrumentalities of the government, central and the state government, can be decided as per the procedure contemplated in the office memorandum. Considering the fact that the petitioner has established its
Receiving
unit-
station.
Huh?
It's called a receiving station.
Receiving station at the in the respondent's land right from 1942. This court deems it appropriate to direct the petitioner to implement the Union of India so that appropriate directions can be issued. The Lysis matter on 11th of February and 11th of.
Could it be on 13th, my lord, instead?
11th of March. Yes.
13th, my lord, instead of.
Yes, 13th of March.
Yes.
By that time, the impleading application shall be filed and also the copy of it shall be served on the panel council appearing for the Union of India. Yes, list on so and so.
Great.
Pleasure.
That is H. Prasanna Kumar in person.
First matter, respondent 4 and 5 auction purchase. First matter, I'm appearing for the auction purchase, respondent number 4 and 5. Bank advocate is.
What
not-
is this petition about?
My lords, this is a surface matter, my lord. I am petitioner. On my request, this matter was taken up for final hearing by the previous bench. I have completed almost 90% of the arguments and my notes of arguments is also placed on record. I filed a memo seeking this honorable court to treat this matter as part her. That memo may please be considered, my lord. I filed a memo on.
When have you filed?
27/2/2026.
2020?
27/2/2026. 27th February.
Then I'll direct it to be placed before the learned judge. It is submitted that a coordinate bench of this court has heard the arguments at length and also a memo is filed by the party in person to treat this matter as a parter. Hence registry is directed to list this matter before the learned judge who heard this matter. Yes, next.
My lord, and sufficient date may be given, my lord.
No, they will place. We can't tell when it should be placed. Yes, 27.
This present
Filed an
petition has
IFR,
got
my lord.
disposed on 1st August 2025.
Mm.
Lord, they have filed application for withdrawal of amount which I deposited before the honorable court. Before this honorable court, my lord. My lord, this is second application which they are filing. My lord, I've But it's
It's
previous.
already order is passed on 1/8/2025.
Yes, my lord, its order was passed. They have filed application for withdrawal of amount,
There was
which
a
I
deposited
deposited before
amount,
the
my lord.
honorable
Interim
court.
order is passed.
I've already said it's permitted to withdraw the amount on 1/8/2025.
My lords, but my lords, in the final order, my lords, it was
It's not
not
forthcoming.
not forthcoming.
IA number 1/2025 is filed. Why did
Please.
you file this? Then you have to ask for a clarification in the order. You file an IA, order is passed, again why it is listed?
My lords, IAS disposed in the final order, my lords. That is the reason, my lords, without taking into the consideration, my lords, we failed to bring to the notice of the court saying that IAS filed, we need a permission to withdraw the amount, my lords. That is the reason. My lords may kindly turn to page 8, my lords.
When was the writ petition disposed of?
My lords, the petition, my lords, came to be disposed on 1st August 2025, my lords. Page number 7.
Impugned order is recalled on trial and this writ petition has become infructuous.
Please, ma'am.
Accordingly, writ petition is dismissed as infructuous. So
Please,
what
ma'am.
is that you want? I'm not able to
My lords,
understand.
I filed an IA, my lords, to withdraw the amount. There is a deposited amount of 5 lakhs
This
rupees.
is, this order has no value. This order,
My lords, apology, my lords.
show it to him. Yes. Next. Show it to him, that order, to the council. Yes, next, call the next matter.
For the petitioner, my lord.
Yes.
My lord, writ petition 18220 is concerning me being classified as a willful defaulter by, under the RBI master circular by the respondent bank.
Yes.
My lord, just a few facts for the background, my lord. I was intending to travel abroad, at which stage I was restrained on the ground that there was a lookout circular issued as against the petitioner. At which stage, my lord, the petitioner came before this honorable court and impugned the lookout circular, which eventually came to be allowed. And this has been challenged by them before the honorable Supreme Court. This is the order of the coordinate bench, my lord. At that stage, my lord, I learned that I've been declared as a willful defaulter. Give me the first writ petition.
That is in respect of, my lord, 17.
No, first I'm looking at
Please, my
this
lord.
WP number.
Yes.
7373 of 2024. Please come to that.
Sale notice is held before the summit. In fact,
My
sale
lord,
to-
what I requested, my lord, why these matters were clubbed, because this first writ petition of willful defaulter may have some relevance, my lord.
No.
If I may be permitted.
Now, you
Yes,
say, if the relief first you sought is, to issue, the second is declaring the bank to conduct sale of the petition scheduled property afresh in accordance with law. That is what you are seeking.
7373, my lord.
Yes, 7373.
Yes.
So now this auction was conducted? Yes, Mr. Vignesh
my lord,
Shetty.
in the year of 2000, my lord, 2022, 2017.
Yes, ma'am.
It is conducted.
It was conducted, it was sold. I'll just tell my lord the few facts, my lord, which are common thread in all the three matters. My lord, I had borrowed certain amounts of money. That is Mr. Hanif Seth, one of the petitioners, Mr. Gauss Seth, the companion petition, father and son. They had borrowed certain sums of money for their business from the respondent bank. After that, my lord, they had certain difficulty because of the father having some health difficulty. When the bank issued a notice, they replied to the bank and they went one step ahead. They told the bank, sir, here is the property. We are giving you physical possession of the property. They also told the bank, sir, I've got a buyer. Because there are three ways to sell the property. One is by private treaty, one is by auction, and any other means. We brought a buyer saying that here is a buyer, please sell the property to the buyer and collect the money. They reject our proposal and sell the same property to the buyer's own immediate family, daughter or daughter-in-law or something, at maybe 1/3 the price.
Yes.
Now, my lord, insofar as Mr. Gauss Seth is concerned, because the bank had started proceedings before the Debt Recovery Tribunal, this ground was taken, saying that this auction had taken place and the property was not to have been sold at such a low value. The Debt Recovery Tribunal in the OA proceedings started by the bank, not in the Section 17 proceedings. Debt Recovery Tribunal said, in a proceeding under the OA, I'm not willing to decide it. You please go before any other forum. Now, these three petitions, my lord, the first petition, which is WP 18220, is the classification of Hanif Seth as a willful defaulter. The other two companion petitions are saying that even before an auction proceeding was started under Rule 8 and Rule 9, including issuing a valuation or something, when they have not passed an order under Rule 3A, and when there is an offer to sell by the borrower, could they have proceeded to sell the property?
The auction was conducted in the year 2018.
Yes.
18.
Sale certificate was issued in 2018.
Yes.
Why you have come to the court in 2024?
My lord, insofar as Mr. Gao said, my lord is pleased to see, the matter was at large before the Debt Recovery Tribunal. Please see in writ petition 7373 of 24, page 96. That is the OA passed on 13th September 23.
So you can't file an essay before the tribunal?
My lord, because we had already gone in OA and we had raised an issue, my lord, of as per Mardia Chemicals, as per Rule 3A. Because, my lord, after we have given possession of the property, they have not commenced any proceedings under Securitization Act to challenge under 17. When we raise this issue of sale, what the Debt Recovery Tribunal says, my lord, that we should seek remedy in a manner known to law. That is in 2023, 13 September 2023. So in the first matter, my lord, as far as willful default is concerned, ours is only on audio alteram partem. And the coordinate bench of my lords was hearing this matter, asked them, Mr. Vignesh will clarify to my lord, whether they have any document to show that they have served the notice on to us. And he fairly said that they do not have any.
That's why I want to ask you.
Yes.
Are you not aware of the sale?
My lord, I am aware of the sale. I am aware of the sale insofar as Mr. Gao said.
Is it not a measure under the Surface Act?
It is, my lord. But whether I'm raising the issue for my lord's kind consideration, that it is adopted a procedure which is not contemplated under the
Question that.
in this OA, my lord, in OA 208
How
of
can
18.
you question it in a OA
My lord,
by
that,
them?
I mean, the point is it has been raised.
No, but
No, I'm saying.
that's what the
Yes.
tribunal said. The procedure known to law. The procedure known to law is under 17.
My lord, I'm just saying for my lords, we are raising the issue of also Rule 3A, which I'm most respectfully
You may be
submitting.
having 101 legal issues, but there is a time,
I bow down.
place
Yes.
to agitate it.
Yes.
When the auction is conducted, third party rights have accrued in the year 2018 and they have
Yes.
been in possession of the property.
Yes.
And in 2026, you ask the court to decide all
My
this.
lord, this was settled in 2023, that is 13 September 23, insofar as Mr. Gaussait is concerned. And after that, we have come before my lord on 8/3/24. Now, what we have raised the issue, my lord, is unlike a typical borrower who would fight the proceedings and say, I will repay the loan, here is a case where I offer the possession of the property back. And I also get a purchaser. Therefore, it is in that circumstance I've come before my lord. And my lord, the first writ petition, actually, that's why I wanted to request my lord to kindly consider. The first writ petition, which my lord is pleased to see, is a willful defaulter matter. The reason is that gives the basis.
Consider that writ petition independently.
My lord, why it was clubbed, my lord? Why it was clubbed?
No, that we will see.
Yes.
As far as this first writ petition is concerned,
Yes.
this 7373, we
Yes.
need not look into it. Then why 18220 is what?
18220 is without a notice being given to me, and as per the RBI master circular process is.
But that we will hear.
Yes. Yes.
WP 18220 will hear.
Yes.
Then what is this WP 756?
Both are the other two, my lord. If I just take few minutes of my lord to take my lord through the facts in these two petitions, and as I already said, my lord, whether once I have offered the property for sale under Rule 8, and after I have delivered back the possession, were they bound to commence proceedings under Rule 8 by issuing me a notice for sale? If they would place before my lord the records to show that after I have delivered possession, my lord, Rule 8 particularly says, I'm just saying a summary way, my lord. Rule 8 particularly says that once securitization proceedings start, we do not have to go for everything under a public auction. We don't have to. We can even sell it under private treaty. Now, When I am agreeing to sell it and realize a larger amount at 9,000 odd rupees per square feet, it doesn't make logic for them to sell it at 3,000 rupees a square feet to the very same person's daughter or daughter-in-law. That is my contention insofar as that is concerned. And they will have to show to my lord whether they have followed Rule 8, Rule 9.
Let's take that writ petition.
Yes,
That-
That is writ petition
When is the first?
7373, my lord.
First 7563 we
is the
need to
first
take. That's so 182, 18220, 38.1.
18220, my lord. Yes.
My lord, 18220, my lord, it is, my lord, willful default of the SIL, my lord, challenge before this honorable court. Wherein, my lord, the
So they
interim
have
order
a
that-
lot of difficulty in that. my lord.
No, not difficulty. My lord, at the most, my lord, that's, my lord, this honorable court granted interim order. That, my lord, we are challenged before the honorable apex court. Therefore, my lord, this 18220, my lord, is
Pending before the apex.
No, no, it's not. It's not.
My instruction-
18220 is not.
No, willful defaulter, my lord, the interim order, my lord, which we challenged before the Supreme Court. I took an instruction from my client, my lord, it's pending before the Supreme
There's no interim order, my
No,
lord.
no, not interim order. It's pending before the Supreme Court. Therefore, my lord, it may be
No, no, I'm
deferred for a
sorry.
week's time. No, it's a matter of fact, my lord, I took.
Not
an
aware
instruction-
what my learned friend is saying.
In fact, I took an instruction on complete instruction. I'm making this submission in respect of willful defaulter. My lord, the interim order granted by this honorable court, we challenge before the honorable apex court. In fact, my lord, I can furnish the SLP number also.
This is the only case which
No,
is
no, no, no.
disposed.
That's I.
18905.
No, that is in respect of
18220, there's no order by this honorable court.
18220 my lord, kindly see the prayer sought before this honorable court.
No, no, what's the interim order in this?
My lord, they're permitted, my lord, the petitioner to, my lord, travel abroad.
That you have questioned.
That I have questioned
That is
before
in
the honorable.
18905, my lord. I think my learned friend is a
Where
little.
is 18905?
It's already disposed of. That is before the Supreme Court. That's what I'm trying to clarify. There's some
My
confusion.
lord, kindly come to, my lord, 18220. Kindly come to the prayer sought before this honorable court at page number, my lord, 24.
Willful defaulter.
Willful
That's what
defaulter.
is questioned in the interim order.
Please, my lord.
Where is the relief that he sought to leave the country?
My lord, in fact, he filed an IA, stay the operation of the execution.
No, Mr.
Vignesh Shetty.
Vignesh Shetty, look at that order.
I'll give it a.
My lord, in respect of
Maybe
18220.
probably again is that you have filed a writ appeal, I mean,
Yes,
the
yes.
SLPs. Look at that order, give it to him.
This is, I think, your little. There's
My
overlap.
lord, in respect of 18220, the question raised before this honorable court in respect of
At
willful
least,
defaulter.
at least you can tell the court what is the date of interim order, so that the court will see.
I'll also look at that SLP, my lord. I'm not aware. I'm aware of one SLP in this matter.
Let's see. Where is the order? Which date is the order? 18?
18, my lord, 220.
Oh, yes.
My lord, I'll just clarify, my lord.
Who makes this one? Kept it specifically like.
There is an order in WP 18220 of 2023 and WP number 18905 of 2023. Probably that case is disposed of.
Yes,
That's the interim order is pertaining to that
that
case.
case.
That
It was
my lord-
clubbed.
That 18905.
Yes.
It's clubbed and, my lord, pass an order. That order.
That's finally that's disposed
Please,
of.
Yes.
please, my lord.
So that's against that you must have filed the
SL.
SLP.
Lord, my respect to submission before this honorable court. In respect of willful defaulter, my lord, it is altogether different aspect. Whether, my lord, classification by NPA is not, my lord, kindly, my lord, in connected to writ petition. They assailed, my lord, my classification NPA in the year of 2017 and sale took place in the year of 2018, which sale certificate issued in favor of, my lord, respondent number 2. That nothing to do. That's an independent relief, my lord, they sought before this honorable court. In fact, I filed my detailed statement of objection. First and foremost, my lord, I took a contention, my lord, delay and latches. 2017, they handed over the position of property. I sold a property in the year of 2017. I handed over the physical position of property in favor of auction purchase of 2018. 2024, my lord, they came before this honorable court seeking some relief, my lord, which is nothing, my lord, it is nothing but abusing the process of law. At the most, they would have gone in the year of 2018 because they are well aware they're in the position of the property. They would have gone in the year of 2018 or immediately, my lord, I sold a property. They're not, my lord, they're not gone so. My lord, in the present petition or whatever 18222023 in respect of willful default, which, my lord, my duty, my lord, I have to demonstrate whether I issued a notice or not, audio alternate pattern I given or not. If I'm failed to demonstrate, at the most this petition will succeed. That is nothing to do with the surface sale. That is my submission before this honorable court.
What is that?
My lord, in respect of 18220.
No, even if you're, if you're not followed the procedure.
In respect
In
of
that
one.
case also nothing will happen. It'll
No,
be
no,
as. it is.
my willful default of notice will go.
Hmm.
What I issued notice, my lord, that is.
That
my
will
lord,
go.
That will go, that's all.
So
That-
as far as that is concerned, you please argue that writ petition will
Please, my
dispose it off.
Please, my lord, I'll answer.
Yes.
If, my lord, one indulgence, my lord, if 18220, if my lord have it, my lord, tomorrow or day after tomorrow, I'll secure some instruction in respect of whether against this matter any appeal is pending. Otherwise, my lord, I'm ready with my submissions in respect of.
List these matters on 9.
Lordship, in 7563, we are the purchaser.
We'll see, we'll see.
Yes, please.
Your lordship permits, small submission, serial number 46, kindly a week's time may be granted, my lord. Afternoon, I'm a little inconvenienced.
Afternoon, when your court is not sitting.
Court is not.
With your lordship's permission.
It's a week's time, my lord, 46.
It's a fresh matter.
Yes, ma'am.
Tata
on
Capital Housing Finance Limited.
Yes, ma'am. Or on Tuesday also, my lord.
No, by the time you come on Tuesday, please examine the maintainability of the writ petition in the light of the Supreme Court judgment. Where is the judgment? Morning he has not given. In the light of Phoenix ARC Private Limited.
Please.
Versus Vishwa Bharati Vidya Mandir arising out of Karnataka High Court. Supreme Court said writ petition is not maintainable.
Tuesday then, my lord.
Yes, there's a matter on Tuesday.
Lord 50, yesterday, my lord,
I'll call if this is not the way we can complete this.
sorry.
Then 39.
My lord, sir.
39, my lord,
My lord,
please
this
pray for, my lord.
KPID and.
Matters have been argued extensively before your lordship, my lord. In fact, my lord,
KPID and Suffici Act, my lord,
to be
NSCL
discussed.
judgment, my lord, pass some, my lord, we are requesting this honorable court to pass an order because we argued the matter, we have placed all the judgment before this honorable.
Yes, we'll pass orders.
My lord, Samdi.
Matter. No, again, I'll let my memory be refreshed. It's been long time that I heard it.
Please, Lord, please.
This is a matter on 11th of February. We'll hear it on that.
Great.
One submission, 62, my lord, may be taken.
I'll call.
11th of March, my lord.
40, your lordship.
11th of March.
Represented the
11th of March, my lord.
Yes.
It was said
40.
February.
40, petitioner, your lordship. Kindly. I append the petition, lordship.
Last occasion.
15 days quarter, out of 5 cases, your lordship, already 4 settled. This is also going to say, okay, 15 days time may be granted. 15 days time may be granted.
Why we should grant 15 days time?
Because this is also 5 out of 5, 4 has been already settled. Only this was left out this one. That's why I'm asking. Otherwise, I need not ask. He also never, and we have deposited the 40 lakhs last week only and settled 4 issues out of 5. This is the only issue regarding. And 15 days time I will.
If you wait, if you give up.
Sorry, your lordship.
Yes.
Sorry.
On the last occasion, they made the same
Submission. This is a matter finally on 16th of March, no further time. Yes, next.
Interim order may be extended, my lord.
Interim order. In all these matters, wherever adjourned, extend the interim order, whether they ask or not. 41?
41?
Yes, list the matter on 17th. 42?
Lord, 42, my lord, I have an urgency, my lord. There is an interim order which is operating. Tomorrow.
Yes.
We kindly have it on Monday, Milords. We have for the
No, my
petition.
lord.
Monday,
Please,
Tuesday,
tomorrow,
any
my lord.
date next week.
Lord, there is an interim order which is operating since 1 year, my lord, not to issue the sales certificate.
We are ready to argue today also, but
Yes. So we
tomorrow
can
I
argue
have some
tomorrow.
inconvenience. My colleagues waiting, my lord. Kindly have it on Monday, Tuesday, next
Tuesday
week.
will have. Monday they're already submitted several.
I am not there next week, my lord. Then 13th, my lord.
13th.
Lordship may have it on 13th.
Yes, 43. Interim order, extend. 43.
Your lordship.
44.
43. There's an urgency in the matter because without having a clear encumbrance, they have sold the property to an auction purchaser.
25 they've done it.
Sorry.
Lordship, January 25, my lord.
List this matter on 24th of March. Yes, next. 44.
44, I pray for responding in this matter.
44.
Lordship, in this matter may be kept on 10th. The similar matter.
The matter decided by this honorable court, subsequent, but Jiju Vargi, MSCB, my lord, guidance, my lord, challenge before this honorable court, wherein the party resides at Kerala. This honorable court passed a detailed order. They filed one more writ petition, my lord. It is, I took a condition last date of hearing, my lord, is constructive res judicata.
Oh, that Canada
Same, my lord,
Bank,
one more writ petition they
something which
filed.
is in.
Very
Yes,
same,
yes, my lord.
same,
No,
lord.
we'll have it tomorrow. List is matter.
No, my lord, this may be kept. Similar matter is there on board on 10th. So this may be posted along with that matter.
What is the number? List along with so and so on 10th. Yes, 45.
45.
I'm grateful.
Mahesh? Number.
Yes, this matter, I think this is a fresh matter tomorrow. Yes, 47.
Then 47. Giri K.
47. Tomorrow. Yes, 48.
Appearing for respondent, my lordship.
Tomorrow. 48.
40 appearing for respondent, my lordship. This is now not comes under the adjudication, it comes under DRT. Already they filed DRT. Say, my lordship. The entry model is not compliant still.
It will come. List this matter on 11th. Yes, 49.
Appearing for respondent number 1 and 2, my lords.
Who moved the memo? What is the great urgency for a 23 matter? You moved?
There is a 52 lakh outstanding amount as of today, my lords.
You are for the respondent bank. Tomorrow. It's 50.
Lord, 50, your lordships may see the judgment. That paragraph, my lord, there was a confusion. Say that case, my
Tomorrow
lord.
we will. Tomorrow. Yes.
Allah, there is some urgency, my lord.
He has already constructed the house. He has put up a temporary construction there. The only issue is that he has given an representation to the DAC. I think it has been forwarded. We may require up to 15 days time.
No. There is no question of, my lord, considering the representation. Though there is an interim order, lordships will see 56.5. I'll show that paragraph. It may be disposed of in line with the same.
Tomorrow.
That will not be possible, my lord.
No, they don't have to consider the representation. They don't.
Yes, tomorrow.
Mallikarjunaya.
Yes, this in the month of, this on 24th March.
52.
Appearing for
Shahnawaz.
52.
Appearing for respondent, they claim to have paid the entire dues, but then there are dues they have not paid. So I'm filing objection.
Tomorrow. 53.
53.
And for petition
respondent bank.
tomorrow, my lord.
Tomorrow. 54.
54. V. Mohan.
This matter on 18th of March. 55.
55. Narayan Bhatt.
55, your lordship may have it on 12th or 11th, my lord.
13th.
Please, ma'am.
56.
56.
Some urgency in this matter.
Tomorrow. Tomorrow.
A stay may
57.
be greatly extended, my lord.
57, I begs to appear on behalf of petitioner. My lord, it's covered by judgment. My lord, sales certificate, my lord, needs
Tomorrow.
to be.
For respondent, my lord.
Tomorrow.
Respondent number 2, my lord, I will file my statement of objections, my lord.
We'll see.
Kindly,
We'll see.
please.
58.
58.
Hanumantappa Arvi.
My lord, I pray for petition in this matter.
It's a fresh matter, I think.
Special, in fact, this honorable court came earlier, my lord, in fact, granted an interim order not to precipitate. They are supposed to file an affidavit before this honorable court. They're not.
Tomorrow? Yes, tomorrow. 59.
59. Deepak.
This is also, my lord, I begs to appear on behalf of.
Tomorrow.
60.
Yes.
Hanumantrayappa.
All these partner matters. List on 25th of March.
One submission. Partnered matter 61, malad urgency. There is a disability PDS matter.
Tomorrow, 61 tomorrow. Remaining other matters on that day.
List number 2.
Yes.
Number 1. Prakash MH.
All these matters repeat. List number 2. List number 2, remaining matters repeat.
Lords can leave, my lord. Still number 39, the lordship say kindly please to post on 11th, some personal inconvenience. Could be 12th, my lord.
11th.
Lords,
Sir,
one submission.
It's given on 11th. May I have it on 12th, please, my lord?
12th.
Deeply obliged. Deeply
Lords,
obliged.
one submission, my lord. List to seal number 9 and 10 minutes. I am for the petitioner. There is one more connected matter. It need to be tagged along with this.
List along with that tomorrow. Take that number.
Let's
Any
serial number
signatures?
37 minutes. I'll make IAS not pressed minutes. Apology minutes.
It's already there.
Please. Oblige minutes.
My lords, may I request for?
The second list will be
My lords,
repeated.
may I request on Tuesday, my lords, Tuesday or
Let it come,
Wednesday?
let it come.
Tomorrow I
All
have some
matters are-
inconvenience.
With great difficulty, they have picked up all those matters. Let
My
it
lords, tomorrow I have some inconvenience, Tuesday or Tuesday, my lords.
Yes, one day itself, this is the matter,
Oh, bless
along
you.
with the other connected matter.
Serial number.
Serial number.
ಹೌದಾ? ಇರಿ. 9 and 10 ಮೇಡಮ್ ಹೇಳಿದ್ದು?
Yes, sir.
9 and 10 ಮಂಡೇನಾ?
ಹಾ.
ಒಂದ್ ನಿಮಿಷ ಇರಿ, ಅದೊಂದು ಬರ್ಕೊತೀವಿ ಇರಿ. ನಿಮಗೂ ಬರ್ತೀವಿ. ಒಂದ್ ನಿಮಿಷ ಇರಿ. 9 and 10 ಮಂಡೇನಾ?
ಸರ್ ನಾಳೆ ನಾ ರಿಪೀಟ್ ಅಲ್ಲಿ ಲಿಸ್ಟು
ಹೇಳಿ ನಾಗೇಶ್. 16 25ನೇ ತಾರೀಕು ಹೇಳಿದ್ರು. 25 ನಂಬರಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್ ಲಾಸ್ಟ್
16 ಡಿಸ್ಪೋಸ್ ಇರ್ಬೇಕು ಸರ್.
ಹೌದಾ?
ನಾ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್.
ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಅಂತ ನೋಡಿದ್ರೆ
ಸರ್ ಲಿಸ್ಟ್ 1 16
16
16 ಅದು DNP ಆಯ್ತು ಅನ್ಸುತ್ತೆ.
DNP ಆಯ್ತಲ್ಲ?
DNP ಆಯ್ತಾ?
ಅದನ್ನೇ ಕೇಳಿದೆ.
Sir, 48 serial number.
ಲಿಸ್ಟ್ ನಾಳೆ ರಿಪೀಟಾ?
ಇಷ್ಟು ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ. ಎಕ್ಸೆಪ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10 and 11 ಮೇಡಮ್. ಮೇಡಮ್ ಮಂಡೇ ಅಲ್ಲ ನೀವು ಕೇಳಿದ್ದು? ಮಂಡೇಗೆಲ್ಲ ಅಲ್ಲ ನಂಬರ್ ಕೊಟ್ರಲ್ಲ?
ಕೇಳಿದೆ ಸರ್ ಮಂಡೇ ಅಂದ್ರು.
ಮಂಡೇ ಮೇಡಮ್ ಹೇಳಿದೆ.
48 sir, reach ಆಗ್ಲಿಲ್ಲ.
ರೀಚ್ ಆಗ್ಲಿಲ್ಲ, ಡೇಟ್ ಕೊಟ್ರಲ್ಲ?
ಹೌದಾ?
11/3
11/3 ನ.
ಒಂದ್ ನಿಮಿಷ 44 ಅಲ್ಲ?
ಓ, ಈಗ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ ಈಗ?
ಎಲ್ಲ ಕಾಲ್ಫಾರ್ಟ್ ಮಾಡಿದ್ದ ನಾನು ನೋಡಿಲ್ಲ.
ನಾಳೆ